করে নিন।
হ্যাঁ নিশ্চয়ই।
Please, your lordship.
Yes.
That matter, Mr. Soibal Acharya mentioning that last Wednesday, lordship directed the sharp the copy. Matter will come in the list. Go out of the list, but for that reason,
What is the matter? Second appeal.
no, read
Writ. Group 8 matters.
group 8.
So you are for the
I am for the petition.
petitioner. Okay.
Lordship, may I
State.
Lordship, may I permitted to
come in the
mention
list.
three
It
matter.
will be appear in the list within 2 or 3 days.
Wow.
Wednesday, the lordship. Group 8.
One second appeal, Lordship, one hearing matter and 2 application.
One hearing matter. Hearing of second appeal.
Second appeal, Lordship.
Ready matter.
Yes, already
You are the appellant.
I am the appellant. Already run in the list, earlier bench, up to after the
Paper book ready. Everything ready.
Everything. Lordship. And another 2 application, Lordship.
Application in connection with the same.
Second appeal.
Same.
No. Another matter.
Another 2 appeals.
2 appeals. Another 2 appeals. 2 application.
What are the applications?
Application for substitution and others application for direction of the filing paper book, bringing the lower court record, such and such.
Second appeal will appear, this matter, on 6th of December. Second appeal. 6th of December. Applications will appear on 29th of November.
Other side appear. They appear for hearing.
Now, what is the procedure second appeal before admission? Whether section 5 has to be heard. So the single, the application under section 5 of Limitation Act has to be heard by the single bench. Thereafter, it will be appear before the division bench, whether there is substantial question of law or not. Okay. For the appeal for the year 2003, since 2003, it is pending for hearing limitation application. Why so delay? Application pending for 20 years. Now you are the advocate on record, you are to blame. Then why have not moved this matter? 22nd.
My lord, my lord.
22nd, you serve notice upon the petitioner, upon the respondent or opposite parties, that the matter shall appear in the list on 22nd of November. 22nd of November.
My lord, allow me to make a mention for hearing, my lord. It's a group 8 matter, my lord. The matter is relating to renewal of license of a ration shop, my lord. Kindly let it be appear for hearing, my lord.
For hearing or new motion?
For hearing, my lord.
For hearing?
For hearing.
Pleadings complete?
Yes, my lord. All the
for the year?
Complete, my lord.
Read petition for the year. What is the number?
2022, my lord. 2022.
My lord, may I mention
Grateful, my lord.
I mentioned my application for extension of interim order. My lord, it's a WPA from 2015, a writ petition. The interim order had expired in July 2020, this year, 2024. I had mentioned the matter in September 2024, but the application has not been listed yet. We had filed the...
Have you mentioned it earlier?
We had mentioned in 9 September 2024. On 9 September, we had mentioned, but the application has still not come. The application for extension was filed before the interim order had expired. This was mentioned on 9 September.
মেনশন করেছিল লিস্ট করনি কেন? মেনশন করেছে তো বললো। হ্যাঁ ফাইল না এলে রিকুইজিশন দেখুন প্রয়োজন কি দেখেন করলে করে দিন।
My lord, the application was filed in July 2024 this year.
Are you mentioning this matter today or you have
No,
mentioned
we had-
earlier?
We had mentioned it earlier in September
Okay.
2020,
Okay, I'm taking.
September of this year.
Yes,
May I have your lordship's kind leave to mention, my lord, applications in connection with second appeal, my lord, all of my lord, substitution application appearing for the first time, my lord. My lord, one second,
6th of December.
my lord, one
How many matters are there? Two matters.
my lord,
Two matters.
four.
Four matters.
Application, my lord, application, substitution,
Matter may be application.
Application.
Why four matters altogether?
my lord, application only.
One FMA.
Yes, my lord, against the order of remand.
Then you have to mention it. Why you place all the
But-
matter altogether?
My lord, only application, my lord, substitution application, my lord, appearing for the first time, my lord.
You have mentioned that it is connection with the second appeal.
Yes, my lord.
And
And
one matter is
one
there.
matter, my lord, in relation to a order of remand, my lord.
And you have to mention it. Why you place all that seat together? You have to mention one after another, not like that. Okay.
As well.
So what is the matter? FMA?
FM, my lord, against the order of remand, my lord.
What or remand is there?
Yes. But my
You
lord,
are
the
you are
suit was decreed, my lord. I preferred the defendant preferred an appeal, my lord. The decree was reversed. Against that order of reversal, my lord, I have preferred this.
so why FMA? It is
FMA, my lord, because it's an order of remand, my lord.
okay. It is first appeal,
No, my lord, first miscellaneous
first
appeal.
miscellaneous appeal.
Yes, my lord.
Okay.
And my
All
lord,
20, all 6th of December.
grateful.
Lord, may I
And
have
my
your
lord, one
lordship's-
second appeal hearing, my lord. Ready for hearing, my lord.
You are
I am for the appellant.
one day 5 mentioning.
And my lord,
This is the last time I'm allowing you.
Yes.
One day, not more than 2. 6th of December.
Lord,
All
may I
the-
have your lordship's leave to mention one second appeal for hearing? Lord, the appeal has already been admitted, my lord. It is at the hearing stage.
You are the
Lord, I'm for the appellant, my lord.
appellant. Who is for the respondent?
Lord, I'm not aware of that's an old matter, 2014 matter.
2014 matter. Paper books ready.
Paper books are
Otherwise,
Ready for
without
hearing.
the ready of, I will throw it out. You have to mention it
I
again.
understand.
Okay. Okay. Take it. 6th of December. I will take all the matters.
My lord, I am mentioning one section 5 application in connection with second appeal of 2015.
2015. It will be appear on the list on 22nd of November.
Grateful.
That means this month Friday. This
Yes.
week Friday.
On contempt application, Your Lordship.
Content application of what?
Your Lordship's order was passed on 5th August 24
Connection with
in connection with Group 8 matters. my lord.
Group 8 matter.
My lord. The order has not been complied with. This.
What order?
The Lordship was pleased to.
Is it a final order or
Yes,
interim
final
order?
order, final.
Final order.
Yes.
List it.
Lordship may mention
Application for repairing in connection with second appeal. You are the appellant tenant. Appellant tenant for the year 2007. Who is for the respondent? Have you served it? What is the matter of the appeal? Whether they are appeared in the appeal? They have not appeared in the appeal. Have you served the notice of appeal? Notices of appeal has been served. Let it be list. 6th of December.
My lord, may I be permitted to mention a appeal hearing, second appeal, I am for the respondent, notice given to the appellant,
6th of December.
6th of December. Explain.
Your Lordship, I'm mentioning for 3 applications in connection with second appeal, Your Lordship. One is of
What are the applications?
one is for repairing, another is for change of circumstances. Status quo was there due to change of circumstances, and another for substitution.
Substitution. Okay. Take all the
I've
matters.
served upon the other side, Your Lordship, 3 matters.
You are the appellant on all the matters?
All the matter, I'm the appellant.
Okay. 6th of December.
Your Lordship,
2000? I have already determination up to 2017. This is the a matter of 2000. 24 years has already elapsed.
Matter was in the deep cut after
You are for the appellant. Who is for the respondent?
the respondent that appear as
Paper books are ready. Okay. 6th of December.
Your Lordship, may I mention a matter for inclusion, second appeal, all the paper books and everything is ready, matter is ready for hearing. I'm only mentioning for inclusion in the list for hearing.
13th of December.
Madam, may I permit to mention?
13th of December.
Madam, may I permit to mention, madam, for
Just wait.
Madam,
Got it? 13th of December. Yes.
may I permit to mention, madam, for hearing of Group 8 matters, madam,
Group 8 matters. For the year?
2024, madam. Madam, affidavits already completed, madam.
Readings complete.
Madam.
Listed.
Lordship, may I be permitted to mention for inclusion?
Accordingly, it would be listed in the back. You know the rule of the old matters will be listed first,
It
thereafter.
was already
This is
listed,
24 application.
It was already listed. Madam, due to madam expansion of interim order, madam, I have to mention before the honorable Justice Raichota, madam, that is I.
Very well. List it.
Lordship, may I be permitted to mention one matter for inclusion for substitution application, Lordship?
In connection with second appeal.
First appeal, Lordship.
First miscellaneous appeal.
First miscellaneous appeal.
6th of December.
Grateful.
6th of December.
Lordship, may I permit? Second appeal, your Lordship, 2005, this is second appeal, your Lordship, paper book is ready.
Second appeal
Second appeal matter
for the year
for the 2005, your Lordship.
2005.
Senior citizen. And appellant is, appellant is enjoying stay 6 long, your Lordship.
You are the respondent.
Paper book is ready, your Lordship, for inclusion.
6th of December.
May I also mention one matter for restoration application, madam?
Restoration application.
Yes, madam.
For what? Restoration.
It was dismissed for default. 16th
Restoration of
July.
group 8 matters.
A group 8 matter, madam.
Okay. Call the list.
Madam.
My lord, in item number 4, I am representing respondent number 7. Item number 5, my lord, I am representing private respondent number 10. And in item number 6, my lord, I am representing the petition. My lord, on last week, I started making submissions before your lordship. Lord, with your lordship's leave, may I continue the submission?
Yes.
With your lordship's leave, may I continue my submissions?
Yes.
My lord, on last occasion, my lord, I was referring to a law relating to the point that the son's spouse can also be included in the family member, my lord. My lord, may I take your lordship to West Bengal Public Distribution System Maintenance and Control Order 2013 law, page number 1.9, my lord.
What is the name of the petitioner?
My lord, Shukla Dutt.
Shukla Datta, wife of Probir Datta. Yes.
My lord, what happened, my lord?
I take my lord shortly. Yes.
My lord, what happened? The erstwhile petitioner, Probir Datta, after his unfortunate death in the year 2017, his widow, Shukla Datta, was substituted in the year 2022. Probir Datta initially filed this writ petition challenging the order passed by the district controller on 15th December 2014. After his unfortunate death, my lord, Shukla Datta, his widow, came into the picture. My lord, I would take your lordship.
No,
to-
first of all, you have to ascertain
Yeah.
whether you have steps your leg inside the shoes of Probir Datta, or you are coming independently as the widow.
My lord, at present.
What is your writ? Writ is filed by the Probir Datta
Yes,
challenging the order of the SCFS,
yes, my lord. Yes,
who stated that Probir Datta has other separate income. So the Probir Datta cannot be taken to be the license under the compulsory order. This is the sum and substance of the order against you, against Probir Datta.
Yes.
Probir Datta has challenged the same contention. What is the ground? Whether now you being a Probir Datta or predecessor or the successor of Probir Datta appearing before this court, or you are now challenging the order being the widow of Probir Datta.
My lord, as a successor of Probir Datta, because I don't have any sufficient means of livelihood, that's why I have come before your lordship to at least have seek your lordship's direction that I am be allowed to at least claim for the MR dealership as a right. My lord, I would take your lordship to clause M, my lord, or at page number 1.9. My lord, I shall read, my lord. Family member means spouse or parents or son, including son legally adopted before death or incapacitation, or widow of predecessor son or daughter, including daughter legally adopted before death or incapacitation, divorced daughter, and widowed daughter, who is wholly dependent on the dealer or distributor at the time of death. My lord, kindly come to the next page, my lord. Page 1.10.
Yes.
My lord, kindly come to clause XA, my lord.
Yes.
My lord, here the word relative is defined, my lord. Relative includes the family member and the following kin. First, son's spouse, son or daughter. Daughter's spouse, son or daughter. Brother's spouse, son or daughter. Sister's spouse, son or daughter. Parents' brother or sister. Spouse, brother or sister. Now, my lord, on subclause 1, son's spouse, I shall pause. My lord, the definition of family member should be considered exhaustive. That's why family member not only is restricted to clause M, it also includes clause XA also. My lord, I would further make my submission. In support of my submission, I would place before your lordship one unreported judgment by Honorable Single Bench of Calcutta High Court, Honorable Justice Vivek Chaudhary passed an order in the year 2023, my lord. May I submit before your lordship this unreported judgment? Unreported. আমি এটা কপি করতে আমি এটা কপি করে দিচ্ছি হ্যাঁ মোহাম্মদ আরব was state of my lord, may I take your lordship to page paragraph number 8, my lord, page 5, my lord.
Yes.
My lord, I shall read, my lord. Next, the learned counsel for the petitioner argues that while defining relative in clause 2(xa) of the 2013 order, the definition includes family members and the following kin: son, spouse, son or daughter, daughter's spouse, son or daughter, brother's spouse, son or daughter, sister's spouse, son or daughter, parent's brother or sister, spouse's brother or sister. The said clause 2, subclause XA of 2013 order, while defining relative, includes the family members, whereas the clause 2M of 2013 order, while defining family member, does not include the relative only to deprive the relative from getting dealership under 2013 order. Classification must be found on intelligible differentia which distinguishes persons grouped together from others who are left out of the group. Secondly, the differentia must have a rational connection with the object sought to be achieved. By not including the grandson and granddaughter within the classification of family member under the 2013 order, the object of the compassionate appointment cannot be achieved, and hence the grandson and granddaughter should be considered within the classification of family members to achieve the object of compassionate appointment. My lord, in this case, there was this contention that because the grandson was not under the definition of family member, it was under the definition of relative. On the basis of that, the claim was made. Here, my lord, in my case, my lord, Shukla Datto, being the widow of Probir Datto, is coming under the category son spouse under definition of relative. My lord, further, I would submit before your lordship, my lord, kindly come to paragraph 11 of the unreported judgment.
Yes.
My lord, I shall read. As argued by the petitioner, he falls under the definition of relative under clause 2, subclause XA, being son, that is the grandson of the deceased, but does not fall under the definition of family member under clause 2M, which only includes the spouse, parents, son, and daughter of the deceased. Therefore, going strictly by the definition, the petitioner would not be a family member of the deceased, and thus would not be eligible for the license or compassionate ground. But the scheme for compassionate appointment is a beneficial legislation which has been enacted for providing financial aid to the family of the deceased. The fair price shop is the only source of income of the family, and authority should consider the case of the petitioner for engagement. The manner in which the term family members has been described in clause 2, subclause M of the Control Order 2013 excludes many such heirs who are eligible to be included. Paragraph 12, my lord. In a judgment by Honorable Supreme Court in Brijmohan Lal versus Union of India, reported in 2012, 6 SCC 502, it was held that if a policy framed by the government is against any statute or the constitution or runs contrary to the philosophy behind the provisions, or if the same is dehors the provisions of the act or legislations, the court can interfere in the policy of the state. In Srimati Durga Das versus State of West Bengal, in WPA number 11518 of 2021, the Honorable Justice Amrita Sinha of this court held that the intention of the legislature is very clear from the provision relating to engagement on compassionate ground. The vacancy which arises on account of death of any existing dealer is not required to be initially notified. The legislature intends that the family members of the deceased dealer having no regular means of subsistence will be considered with preference for grant of license to continue with the dealership. The very purpose of extending this facility is particularly for the reason that a setup is already in place from where the ration items are supplied to the consumers. The consumers at the same time are not required to switch over from one dealer to the other on account of death of the dealer. In the opinion of the court, the relationships as mentioned in clause 2, subclause M are incomplete and the same needs to be relooked. The case of bachelors and spinsters are also required to be taken into consideration at the time of framing such policy by the state. The policy decision should be in public interest and taken objectively to meet a certain purpose. The policy of keeping the dependent family members of the deceased in the form of brothers and sisters out of the purview of the definition of family members is an arbitrary one. Such constricted approach is definitely not in line with the objective of the scheme. My lord, lastly, in this case, the Honorable Single Bench directed the authority to consider the claim of the petitioner, my lord, on the basis that he falls into the category of relative. 2N, which is also a part of 2XA, which is also a part of 2N. My lord, my client, my lord, I am not arguing on behalf of my client that whether she is entitled to get the MR dealership or not. That is up to the district controller to decide. My point of argument is that, my lord, my client is entitled to at least claim for the MR dealership before the district controller, my lord, because she doesn't have the sufficient means, and as a successor to Probit Daktu, and as legal heir of late Lakshmi Narayan Daktu, my lord. Moreover, my lord, on the petitioner, Sunil Daktu, in his CAN application, my lord, I will take to your lordship. My lord, in the CAN application, the petitioner Sunil Daktu, that is CAN number 11762 of 2017, my lord, the petitioner Sunil Daktu himself added Shukla Daktu as a private respondent in 2017. If, my lord, in that way, if right to be sued survives, then right to sue also survives, my lord, on behalf of my client, my lord.
No, right to sue is different meaning.
Yes, my lord.
Right to sue is different meaning in respect of the sue itself.
Yes, my lord.
If you have the right in the property, if the property is in dispute in the suit, you have the right to sue survive. You have the right, if you have the right to sue being a legal heir of the deceased dealer, the right to sue will be survive. That is the question. But the first
my lord.
question is whether you can come under the definition of family members. Second question is whether you have regular means of income at the time of death of the deceased dealer.
Yes, my lord. My lord,
This is the only law.
yes, my lord. Whether I am entitled to even claim for MR dealership, that I have submitted before your lordship the relevant laws and the judgment, my lord. My lord, even my lord, in the state's report, my lord, Sunil Daktu, because my senior learned friend, Mr. Shaharai, made this submission that the authority didn't consider the representation of the petitioner, Sunil Daktu. In the state's report also, my lord, it has been mentioned that the application of Sunil Daktu was never made in proper form, my lord. My lord, in the supplementary report also, in comprehensive report also, my lord. My lord, rest I would adapt the submissions made by Mr. Chaturvedi in his submissions, my lord, again regarding the state's report regarding Sunil Daktu. My lord, my humble submission before your lordship is that let Shukla Daktu, under the reasonable perception of compassionate appointment, at least she is given a chance to claim for the MR dealership, my lord. Because without MR, without given a chance, that would directly hit the principles of natural justice, and that would also hit her fundamental rights under the Constitution, my lord. That is why, my lord, I would conclude by stating, my lord, that being a widow to Probit Daktu and being one of the legal heirs of late Lakshmi Narayan Daktu, she at least be given a chance to claim for the MR dealership, whether she fits the proper formalities and whether she complies with all formalities, that is up to the district controller to decide.
No, you have to just prove that you have a locus standi.
Yes, my lord, I do have locus standi.
How?
My lord,
we shall consider according to the law.
Yes, my lord.
The compassionate appointment at the time of death of the earlier Lakshmi Narayan Daktu. At the time of death, you are not the widow. You are not the widow. Now you are coming as a widow of Probit Daktu.
Yes, ma'am.
That is one of the son of the Lakshmi Narayan Daktu.
Yes, ma'am.
The Probit Daktu was not declared to be fit for compassionate appointment, as there are, he admitted before the before the authority that you have the license. Prabir Datta had the license.
My lord,
But the license, other license to carry out business and other business he was carrying on.
my lord, let me take your lordship to that notification, that order, which
Yes.
stated that.
That is the only way.
Yes, ma'am.
You have to ascertain this court.
Yes, ma'am. My lord, I would take the writ petition, their writ petition, 34179 of 2014, my lord. My lord,
No.
in
This is the order dated
Yes.
15th of
December.
December 2014.
Yes, my lord. My lord, I would I would take your lordship to last 3 lines.
Yes.
The subdivisional controller, FNS Kandi, is instructed to send a proposal for creating a resulted vacancy at the FPS, provided no legal heir of the deceased dealer other than Sri Probir Dotto and Sri Chandan Dotto and Sri Ranjan Dotto apply for the same. The case is thus disposed of.
Yes.
My lord, on bare perusal of this operating part of the order, my lord, it, according to my little knowledge, it comes to my understanding that this order never completely debars or never permanently debars Probir Dotto from applying. As because at that situation he had a cement dealership, that's why he was prohibited from.
No one debarred you to apply for resultant vacancy.
Yes, my lord.
That is not the provision of law. You can apply for fresh resultant vacancy.
Yes, my lord.
You are allowed always
Yes, my lord.
to apply for resultant vacancy. But
Yes,
the
ma'am.
question is whether your prayer for compassionate appointment can be considered by the authority concerned.
My lord, I'm coming to that.
This para, you are reading this para,
Yes,
first of this, however, during the hearing, Sri Probir Datta admits he being an authorized dealer of Lafar cement since last 4 years.
My lord.
This is the
My lord,
impugned order.
in that para only, my lord, I would take your lordship to third line on that para, as starting from as paragraph 26 of West Bengal Public Distribution System. My lord, I shall read, my lord. As paragraph 20 clause 6 of West Bengal Public Distribution System.
What are you reading?
Yes, my lord.
What are you reading?
My lord, the last paragraph, my lord, starting from the second line, my lord.
Okay.
As paragraph 20 clause 6. Has my lord found it?
The judgment.
Not my lord. In the
Impugned
same,
order.
yes, ma'am.
Yes.
As paragraph 20 clause 6 of WBPDS MNC order 2013 mandates that prayer of any of the family members of the deceased or incapacitated dealer having no regular means of subsistence will be considered with preference on compassionate ground. Now, my lord, in this law which has been mentioned, the family members term has been mentioned, my lord. My whole point of contention is that being one of the legal heirs, because as she falls under the category of relative, man. Now, being under the category of relative shall not debar my client from the category of family members, my lord. Because if the category of family members debars my client from even contesting or even claiming the MR dealership, then the whole fabric structure of family members will be futile, because family members not only is restricted to what has been mentioned in clause 2M, my lord, it also includes clause 2XA. Otherwise, the lawmakers wouldn't have added this part, my lord. In this law, my lord, it specifically states that family members of the deceased dealer having no regular means of subsistence. In my CAN application, my lord, the substitution application, I have mentioned that I have no means of subsistence. Let me claim for MR dealership. My lord, I am not on the point that whether I am entitled to get or not. But on the basis of being under the category of relative, and that thereby being under the category of family members, I am entitled to at least claim for MR dealership along with other legal heirs.
No, statute that the subclause 6 says about the family members.
Yes.
And subclause 1 said about the relatives.
Yes.
There are some difference of family members and relatives. Why the family member is incorporated in subclause 6 and why the relative has been incorporated in the subclause 1. That is a separate understanding of the legislatures.
My lord, but that is why the judgment.
You have placed the judgment
Yes, my lord.
to
The-
show that the
because-
sometimes the persons appear in family member may be considered to be in the number of relative may be considered to be a family member.
Yes, my lord.
Very well.
My lord, I would conclude my submission by stating that being under this category of clause 2XA and thereby being directly falling under the category of 2M, my lord, my client be given a chance to at least claim for MR dealership as she falls under this category, and also thereby she rest can be decided by the district controller if she complies with all the formalities. But she should not be stopped from even claiming the MR dealership, my lord. I would thereby rest by submission before your lordship.
Is there any pleading regarding the business of your husband, Probir Dotto, of Lafar Cement like that? Is
While-
there any pleading in your writ petition?
No, my lord,
You have not pleaded. Okay, very well.
deeply obliged, my lord.
Yes, for the step.
Since it fell from your lordship that the query whether Shukla Datta had the right when, as per clause 1M6, my learned friend has argued that Shukla Datta had a right through the clause son's spouse. But since your lordship had, it fell from your lordship, the query that had she been at the time of death of Lokshinaran Datta, his son was alive. So naturally, son's spouse doesn't come in. There cannot be two persons of the same family applying.
There cannot be two status of a same person.
Same families, two status of the same family. I
person.
stand. So that lordship, I'm trying to find out if there is any judgment to that to clarify this clause. There has been an amendment. So this is the amended clause which has come into effect since 29th of September 2023. So apart from this, lordship, 2M type one clause. Earlier it was this came into this also was amended earlier. Lordship will take the old clause.
1M.
Lordship, this is clause 1M.
Clause 2M. 2M, definitely.
Clause 2M. Section 2, definition clause. Then comes M, lordship. It was family members means spouse or parents or son, including son legally adopted before death or incapacitated, or widow of predeceased son, or daughter including, who is wholly dependent on the dealer or distributor at the time of death. Now, this time of death is important. Now, which has been amended to include, earlier lordship will note that widow of the predeceased son. So, at the time of death, a widow of a predeceased son. But as per the amendment, what has been incorporated is spouse, parents, son, including legally adopted, son's spouse has been incorporated.
Okay. Son spouse.
Son's spouse has been included. So perhaps this predeceased lordship, I'm yet, since it fell from your lordship, I'll take an opportunity to come back with a judgment with a discussion on this point, lordship. There appears to be a difference in the clause, the words widow of a predeceased son and son's spouse.
Yes.
So there is a difference. In any event, what the state stand has been that the application since was not in proper form, and there was a requirement as per form C2. Form C2
With
that
annexure 1.
with annexure 1, there needs to be, first of all, the heirs needs to apply. Second of all, if there is one heir applying, then the other heirs needs to put a no objection certificate. Sorry. If there is certain heirs jointly applying, then also there has to be formalities to be made. Now, the state stand is that that form was not in order. By virtue of the reports that has come in, lordship will see that the stand has been, an opportunity may be given to all the heirs to come back with proper form, and that may be considered. But the writ petitioner, Mr. Sunil Datta, was not interested. He wanted, my learned friend, Mr. Shahare, wanted to argue at length on merits. Now, lordship needs to decide whether or not all the heirs goes to apply, or it is only Sunil Datta.
Yes.
Now, my stand is that all the heirs need to go back and apply in proper form. It is not just Sunil Datta.
No, why all the years?
Now, why all the heirs? Lordship will allow me to come back another day. I'm not fully prepared. Lordship, there is some judgment.
Okay, I understand. So what about the another question raised by the petitioner?
Yes, Lordship.
That the SCFS has issued the phase notifications violating the order of the school. This is the
Yes, another point. Lordship, that Lordship will find that in the report it has been explained that due to the computerization of the process.
report. What report you are referring?
Yes, Lordship, the first report that has come in. This is also in the consolidated report. The consolidated. My learned friend had also placed the paragraph.
Report in the form of composite affidavit.
Yes, Lordship.
Yes. Page.
না এটা আগে রিপোর্টটাই বলছি Yes, Lordship, I'm sorry. Lordship, this is in the earlier report. This is the report.
Not this report.
No, Lordship, this report is, Lordship will remember in what situation this direction was given. The order records that a consolidated report may be made. Composite affidavit. Before that, another report was filed. Just a clarification. February 24, this is now 44. Lordship will kindly take 19th, 28th of March 2024 order, which had called for by which the Honorable Court had called for a report. And the report was filed on 19th of June 2024. Pursuant to order dated 28th of March 2024. Lordship, that this report is not that thick, in fact. This is a thinner report. Tin na, dekho na.
Supplementary report
Supplementary report, yes, Lord.
in the form of affidavit on behalf of respondent subdivisional controller. Yes.
Now, Lordship will computerization টা কোথায়? First report time.
Okay, you come with the
Lordship,
access.
Lordship, I'll come back with the answer. This
Yes.
perhaps this report was with respect to that
The number,
regarding land
number, yes.
numbering.
The
Lordship,
plot
this,
number,
this is settled. I think this
the
issue
go
is no
down
more.
of Lokhinar and Datto and the question thereof. Whether the Lokhinar and Datto was placed the go down, whether it was under the ownership Lokhinar and Datto, like that.
Lordship, this computerization is there in one of the reports. If I'm not wrong, it was in one of the reports that it was explained, and my Mr. Shahare has placed the report also, where he said that there has been, yes, there has been a
Okay, you come back.
the allotment of the cards, Lordship, the happened because it was computerized and the particular Lordship, at page 29, Mr. Shahare has also pointed it out. Page 29 of my the report of the voluminous report.
Okay,
It is there in the list of dates.
Page 29.
Page 29, Lordship, dated 13 September 2022. That is in the left-hand side column. The
Yes.
date is 13 September 2022. Lordship will find that the three vacancies, first, second, and third, and right after that. Moreover, to mention here that before the implementation of National Food Security Act, a digitalization process of all the then categories of paper-based ration cards have been conducted by the Department of Food and Supplies, Government of West Bengal. Lordship, this is the digitalization that happened. However, during the time of such digitalization process, the name of the deceased MR dealer, that is late Lakshmi Narayan Datta, may have been omitted from the departmental portal. As a result, during initiation of the above mentioned fresh vacancy proposals, any such authority of food and supplies department involved on that occasion had not been aware of the existence of any MR dealer in the name and style of Lakshmi Narayan Datta. Hence, this is to mention here that all such fresh vacancy proposals have been initiated only from one single source of FPS for rationalization of ration card population, as the FPS of Muhammad Bhadrodoja was quite overpopulated, which had adversely affected in terms of services through PDS. Now here, Lordship, this is the situation with respect to Lokhinarayan Datta's ration cards. Now, Lordship will also see the number of cars is also determined. There is no dispute about the number of cards. there was a punishment pursuant to the penalty, certain cards were detagged from his license
Yes.
and allotted to somebody else. That
Initially, it was given to the Mukta Begum. Thereafter,
Yes.
it was Badra Joha.
Yes, Lord. Now, since the number of cards is determined, it is possible that the heir who is entitled to the license shall be allotted the number of cards.
Number of cards retained with the Lakshmi Narayan Datta.
Yes, Lord.
So
After detecting what the balance number of cards.
now I can
which was
understand the contention that the latest report
Yes, Lord.
that the cards which were initially earlier detected from Lakshmi Narayan Datta tagged with Mukta Begum, thereafter Badra Joha,
Yes, Lordship.
was a vacancy of Gokarno post office. But why the SCFS has declared other two vacancies?
Lordship, that is also explained at page 29. Lordship will see it is mentions that Bhadraj.
They did not say that those 3,500 cards is not under status. This is not the case of that. That case has only been sought to be made out by the private.
By the private desk.
Not the state. State is saying entire 6,000 cards of my client has been declared. They are categorically.
Not the entire. Lordship, my stand is also that
State has submitted the latest report that 1,500 left out DRC shall be allotted to the second vacancy, known as Gokarno NG Girls High School,
yes,
bearing vacancy ID such and such.
Suspended card.
Suspended cards.
Just a calculation. 3,500 in respect of the private response. Total cards suspended 3,500. Then it's saying additional 1,500 of suspended cards still remains. Because actually definitely first vacancy start partly the card
Tagged
of
with Mr.
my
Mukta
wife was just mathematical. They say 1,500 card of suspended still remains. My entire cards have been suspended back to 3,500. 3,500 are already been given in respect of the first vacancy. So at least 1,500 cards have been taken for that vacancy is concerned from the cards by the dealer was valid.
Yes.
Arithmetic.
Lordship will come back to page 29. The number of DRCs are indicated against each vacancies. And Lordship will also take page 47, whereby 3,500 cards were detagged.
Page 70.
Lordship 47,
47.
whereby 3,500 cards have been detagged. It was a penal action that was taken against Lokina and Dotto.
Yes.
Balance কত ছিল সেটা 1,500 Lordship, may I come back and
Yes.
continue with my?
Next week.
Yes, Lord.
Okay, please take down.
I have not completed my
এই
application.
কাগজগুলো ঠিক করে রাখবে তো, এটা ছিঁড়ে ফেলে গেছে, পড়ার গুলো একদম ছিঁড়ে গেছে, এগুলো দেখে রাখ, একদম নষ্ট হয়ে গেছে, এগুলো দেখে ভালো করে রাখবে তো, এত মোটা ফাইল হয়ে গেছে। Please take down. Argument on behalf of the state respondent heard in part. Let the matter appear in the list on 25th under the same heading.
Lordship has kept it on
25th, Monday,
25th Monday. Very well. I'm grateful. 10th.
Monday, 10th.
For the appeal, my client will not proceed the case, you will kindly matter for non-proceeding.
Are you the advocate on record
Yes, my lord.
for the appellant?
Yes, like initially, my lord, matter, my lord, while in the bar, Mr. Praveen Kumar Samanto, really today, who was the advocate on record. Thereafter, my lord, reservation I have.
So what is your
my
name?
Salatnama, my Somiron Giri, my lord.
Your name is Somiron Giri.
So kindly see the order dated 11th March 2021. That I have appeared and I made an application for setting aside of amendment earlier, my lord.
Do you have any written instruction? Give it to. Please take down. Mr. Somiron Giri, learned advocate on record for the appellant, submits an instruction that the appellant is not intending to proceed further with this second appeal. Mr. Giri has handed over the written instruction of the appellant dated 9th of April 2024. This is of 9th of April.
Yes, yes, my lord.
Let the written instruction be taken on record. Next paragraph. Having heard the learned counsel for the appellant and also considering the written instruction on behalf of the appellant, comma, the instant appeal be and the same. It's the second appeal. Be and the same is hereby dismissed as not pressed. Full stop. Next paragraph. The order under appeal is hereby affirmed. Full stop. Next paragraph. Interim order, if any, comma, if any, passed by this court during the pendency of the instant appeal is hereby also valid. Second appeal disposed of.
My lord, I am for the appellant, my lord. Please assistant, my lord. I have some problem. So many
very-
problems,
very
my lord.
noise.
But this is only non-prosecution of the case, my lord. Only one submission is appellant number 1 is dead. My submit, my request or submission is, my lord, please pass an order of non-prosecution after recording the death of the appellant number 1, my lord. দিয়ে দে ডেথ সার্টিফিকেটটা দিয়ে দে আর চিঠিটা দে চিঠিটা দে
Give me the letter.
Written
Written instruction of appellant number 1.
No,
One.
the others, the other appellants except for appellant number 1.
That means the appellant number 1 has to be substituted.
Right, my lord.
There must have an order of substitution.
My lord, she should be expunged, but I am withdrawing the case, my lord. I am withdrawing. They are not intended to proceed, my lord. Ex parte matter of 2005, my lord. Ex parte matter of 2005.
You just wait.
My lord.
You don't have to.
Only record the death of the appellant number 1, my lord. Because
Let
the
me
matter
find out
will not
the
be
memo.
before you by your lordship, my lord.
Let me find out the memo first. Memo.
এটা মেমোটা বার করো যে 40 পেজ 40 my lord. Page 40. Appeal page 40.
দাঁড়ান দেখেন, চা।
বলো আর কি আসলে সে চলে গেল কোথায় বলে বানা
So Jitendra Nath Haldar was the absolute owner of the house property.
My lord, please use the mic, my lord. I am hard of hearing.
Jitendra Nath Haldar was
The original
landlord of the property.
my lord.
Chobi is the
Wife of
wife
Jitendra.
of Jitendra.
Yes.
And who are the Basanti,
Basanti are the daughters, my lord.
Malati,
They are
Mala,
all the daughters.
and Rupa, all are the daughters.
All the daughters.
So the appellant is the mother. Appellant number 1 is the mother. Other are the daughters.
My lord.
There are no other
No other.
heirs.
Yes.
They have put their signature, but no date has been affixed there.
কি বলছো?
ডেটটা দেওয়া হয়নি চিঠিতে, সিগনেচার
Oh,
Okay, very well. Please take down.
I asked him to. I'm very sorry, my lord. দেয়নি তোকে পাঠিয়ে। দাঁড়া। সেটা তো বলবো। My lord, one thing more, my lord. My prayer is they may be allowed to withdraw the documents, original documents deposited in court, in the lower court, the original deed, my lord.
No, the
Original deed.
deeds
But
were
what
deposited
happened?
before the learned
My
court
lord,
below.
the direction from your lordship to allow them to withdraw the deed or anything replacing by the Xerox copy of my lord.
Very.
Okay, my lord. So kind.
What is your name? You are appearing on behalf of the
I am Soma Panda, my lord. Advocate Soma Panda since 2005.
Uma
my lord.
Panda. You are the advocate on record.
I am advocate on record. I am conducting the case. He is assisting, my lord. She has filed the power now.
Okay.
For High
What
Court.
is your name? Jia
Yes.
Bose.
Any.
Learned counsels Soma Panda, Mrs. Soma Panda, and Miss Jia Bose appeared on behalf of the appellants. Full stop. It is the submission. Next paragraph. It is the submission of the learned counsels on record for the appellant that appellant number 1, Chobi Haldar, expired during the pendency of the instant second appeal. It is the submission of the learned counsels that Chobi Haldar, being the widow of late Jitendranath Haldar, had left for heavenly abode, leaving behind appellant number 2 to 5, being the only legal heirs of the deceased appellant number 1. It is the submission of the learned advocates, learned counsels for the appellant that the death of Srimati Chobi Haldar, within bracket appellant number 1, may be noted accordingly. Next, heard the learned counsel. Here is the copy of the death certificate of Chobi Haldar. It appears that the present appellants are the sole legal heirs of the deceased appellant number 1. Present appellant number 2 to 5 করো উপরে লিখে থাকো না আগের জাস্ট আগের লাইনটা কি বললাম appellants number 2 to 5 are only legal heirs of deceased appellant number 1. There are no other legal heir surviving except appellant number 2 to 5 under the above circumstances. The name of circumstances before the name of Chobi Hazar, the term deceased should be noted. Full stop. Next para, the office is directed to note down the necessary direction in the cause title of the memo of appeal within a fortnight. Next para. Learned advocate on record, Mrs. Soma Panda submits that the present appellants are not intending to proceed further with this appeal. She submits that the appellants has handed over a written undertaking to that effect. The written undertaking is placed before this court. Full stop. Peruse the written undertaking. Next, peruse the written undertaking. It appears that the appellants are not at all intending to proceed with this matter further. Thus, hence, considering the written instruction of the appellant and also having heard the learned counsel for the appellant, the second appeal be and the same is hereby dismissed as not pressed. Full stop. Next para. Appeal under challenge is hereby affirmed. Next para. The connected applications, if pending, are also disposed of. Next para. Interim order passed by this court. Interim order, if any, passed by this court during the pendency of the instant second appeal is hereby also vacated. Next para. The appellant stroke parties are at liberty to return back liberty to file a specific application before the concerned court to return back their original documents according to the law. According to the documents by placing the certified copy of the same documents according to the second appeal along with the CAN applications are disposed of. Written instruction be taken on record.
My lord, may I deposit the special messenger cost to send back the LCR to Dwarka?
Chair is here.
My lord.
Okay. On the prayer of the
My lord.
learned counsel for the appellant, LCR be sent down through a special messenger, cost to be borne by the appellant. Full stop. Next, appellant is directed to place the special messenger cost with the department within a fortnight. On such deposit, full stop. On such deposition of cost, the official appoint a special messenger to return the trial court record forthwith.
Matthew.
Yes. Hmm. Next month. Next month.
But there are two addresses. In one address, Millard, they have received. Another address, Millard refused. Millard, kindly see postal endorsement has come back.
Who are the opposite parties?
The opposite party, Millard, one is bank, another is Millard. The bank is the Millard under liquidation. The Millard, the liquidator.
Chairman, revive and recovery committee.
They are liquid.
Refused.
Kindly see page 5. It has been delivered upon opposite party number 2.
Delivered to addressee.
Yes, that is opposite party number 2. I have challenged the order dated 27 June 2024.
Yes, what is your case?
Millard, I am the plaintiff in the eviction. I have Millard filed the eviction suit for eviction of the bank. Now, Millard, in the meantime, Millard, the bank has gone into liquidation. That's why Millard, in view of Millard, the insolvency and bankruptcy code, Millard, the liquidator has to be made part. Now, Millard, we have additionally, Millard, we have made the liquidator as a party, Millard, upon whom Millard we have also served.
That is the opposite party number 2.
And
Assistant Register of Cooperative Society, Howrah.
Yes. And now, Millard, kindly. Now, Millard, in the eviction suit is only on the ground of default under the Millard section 6 of the West Bengal Premises Act, only on the ground of default. Now, Millard, since Millard 7.1 and 7.2 applications were not filed, we filed an application under section 7.3 for striking of the defense. Millard, that application has been rejected by the impeachment order. Millard, court says that they must get another opportunity to deposit rate and to file 7172. Millard, Lordship knows now, Millard, our special bench judgment has come, which says in view of the judgment of the Honorable Supreme Court case of Chamaria, Millard, Vijay Kumar Singh, Amit Kumar Chamaria, time cannot be extended. You have to deposit within 30 days. Court says there was a earlier suit we have withdrawn the suit. These are the points it has Millard discussed.
Yes, where is the order?
Yes, 22nd, Millard, last Millard certified copy, 27th June 2024. First two paragraphs, Millard, I am speaking over. Third, both three parties. The plaintiff stated that the plaintiff filed the instant suit for a decree of recovery of past position and damages. The defendant is contesting the present suit by filing written statement that the plaintiff stated that the defendant did not file petition under petitions of application under section 7(3) of the West Bengal Premises Tenancy Act 1997. It would be 7.2, not 7.3. 7.3 is my application. within the statutory period as the defense of the defendant against delivery of possession may be struck out for non-compliance of the mandatory provision of 7.1 and 7.2 of the West Bengal Premises Tenancy Act. The learned court advocate stated that the relationship between the landlord and the tenant is an admitted one. The defendant filed written objection to the said application and stated that the said application is misconceived and harassing one. The defendant number 2 stated that Ramkrishna Cooperative Limited was initially inducted as tenant under the plaintiff, and the said bank is included as defendant in this suit. But the said bank was under liquidation since 2012. But this is completely wrong finding. But we have also pleaded the liquidator. Completely wrong finding. The Assistant Registrar of Cooperative Society Howrah was empowered to look after the functioning of the bank by the order of the Honorable High Court, but prior to filing of this suit, the plaintiff has filed a title suit being title suit number 3 of 2011 before the learned civil judge senior division First Court at Howrah, which was dismissed on ex parte order dated 30th July 2005. Further, the plaintiff filed another suit being title suit number 396 of 2016 before the learned civil judge senior division First Court Howrah, which was dismissed on contest on 26 July 2002. The Xerox copy of the said judgment and decree as drawn up in title suit number 397 of 2016 by this court was annexed by the defendant. From the judgment and decree, this court prima facie find that the same questions had already been decided by this court on contest in judgment dated 26 July 2002. The question of struck off defense of the defendant has already been decided by the judgment, also by the court. So at present, this prima facie finds no jurisdiction to adjudicate the same matter once again, and accordingly, the application under 7.3 of the West Bengal Premises Tenancy Act 1997 is hereby considered and rejected, and the recording speaks for hearing of the ground of maintainability of the suit. Then it was speaks for maintainability of the suit, but since my lord has passed and stayed, my lord, the suit is not proceeding. Now, my lord, kindly comes to my application at page 25.
This is the application under
7.3.
7.3.
7.1, 7.2 they have not filed.
No, what about the rent, admitted rent?
My lord, that has also to be deposited.
No, whether they have deposited
No,
the
no,
rent.
nothing.
What is the finding that the earlier the matter has been decided by the court?
No. My lord, that was my lord, the 7.3 that was filed against the bank itself. We did not, my lord, know at that point of time bank was under liquidation. Now, my lord, we have implemented the, my lord, suit has been filed against the liquidator.
No, the impugned order says
Yes.
it is about a judgment dated 26th of July 2022.
That was the earlier eviction suit which was filed directly against the bank. At that point of time, we did not have that knowledge the bank was under liquidation.
You give me the judgment.
My lord,
You give me the judgment.
26 July 2020. Wait.
Why such a finding is there that the issue has already been settled or decided?
This is fresh notice, fresh cause of action. Kindly see, my lord, issue number 124 and particularly, my lord, page number 6. Kindly see. Issue number 124. It has been decided, my lord. This is, my lord, 26 July.
What issue are you referring?
Yes, page 6, my lord, at the top.
Issue number?
1 to 4. Kindly see the first 2 lines of page number 6. In that, my lord, judgment also, in that suit also, they did not avail the, my lord, protection under 7172. Therefore, this is the second default. Revision assignment. What court has decided in that judgment is the landlord-tenant relationship is proved, but if they subject to correction by your lordship, I could not find any observation regarding my lord 7172 in that earlier judgment. Page 6, first 2 line is very clear. They did not, my lord, avail of that opportunity. If that be so, then my lord, their defense was automatically struck off in that suit also.
But why you not challenge the title suit? You challenge the order?
No, my lord, this is fresh, my lord. We have, my lord, filed this fresh section 6 notice has been given, fresh suit has been filed. His present suit is on a fresh cause of action, subsequent default.
No. Landlord-tenant relationship was not proved. Else to prove the fact of induction of defendant number 2 as a tenant.
It has to be because bank was there at that point of time. This in this suit, my lord, it is admitted. Kindly see, my lord, the written objection. Before that, my lord, I would be placing another order before his lordship in this suit.
Yes.
Kindly see this order. 31st May 2023. In this present suit, kindly see, my lord. Plaintiff files Hajira and affidavit in chief. The Assistant Registrar of Cooperative Societies files a petition at that the Honorable High Court as to there is the defendant number 2, my lord. The opposite party number 2. Appointed the revival and recovery committee of for functioning of revival and recovery of the money of Ramkrishnapur Cooperative Bank Limited, but subsequently the Honorable High Court Calcutta exercises the power of the committee, and the Assistant Registrar of Cooperative Society Howrah has been appointed to look after the matter. The committee has handed over the charge of the same to the Assistant Registrar of Cooperative Society Howrah, and now the present petitioner has formed a committee to look after the said matter. The present petitioner therefore has filed a petition for vacating the order of ex parte hearing and an opportunity to file written statement. The plaintiff raised no objection and the petition is hereby considered and allowed. The Assistant Registrar of Cooperatives Howrah is added as defendant number 2. Well, kindly see the last line is very much important. Last line and the date of the order is added as defendant number 2 as per Order 1 Rule 10 CPC, and added defendant number 2 hereby is directed to file a full statement. Kindly see the date of the order, that is 31st May 2023. My lord, therefore, he was added on 31st May 2023. Now, my lord, kindly takes up, my lord, the provision of Section 7 of the West Bengal Premises Tenancy Act.
Yes.
7.1 kindly see, on a proceeding being instituted by the landlord for eviction of any grounds referred to in section 6, the tenant shall, subject to the provision of subsection 2 of this section, pay to the landlord or deposit to the controller all areas of land calculated at the rate at which it was last paid, and up to the end of the month previous to that in which the payment is made, together and interest at the rate of 10% per annum. B. Such payment shall be made within 1 month from the service of summons on the tenant, or this part, my lord, is applicable, or when he appears in the proceedings without summons, he being served upon him with 1 month from his appearance. Therefore, he appeared in the suit without summons. He was added under Order 1 Rule 10 on, my lord, May, in the month of May. Order date is 31st May. Well, from May till within 31st May, he did not file any application under 7172. Therefore, whether he is entitled to get any protection under Section 7, Lordship will kindly consider. This is on the face of it, is barred by statute. 7B says two circumstances. One, where the summons is served within 30 days from the date of summons. And where summons is not served, but he appears, we have to take this date as his appearance 31st May 2023. He personally appeared and he was added in the suit. From May till the passing of the judgment, no application was filed. Therefore, the time limit has already gone. Then, kindly see, Section 7.2. Section 7.2 of the Act. Kindly see. If any proceeding referred to in subsection 1, therein is dispute as to the amount of rent payable by the tenant shall, within the time specified there in that subsection, deposit to the controller the amount admitted by him to be due from him, together with an application for determination of rent payable. No such deposit shall be accepted unless it is accompanied by an application for determination of the rent payable. Once the receipt of the application, the villager shall, having regard to the rate of rent last paid and the period of default, shall make an order directing payment. Therefore, 7.2 also not complied with. Then kindly see 7.3. 7.3. If the tenant fails to deposit or make any amount referred to in subsection 1 or 2 within the time specified therein, or within such extended time as may be, the court shall order the defense of delivery of possession to be struck off and shall proceed with the hearing of this. So neither 7.1 complied with nor 7.2 complied with.
Yes.
And court says, subject to correction in the earlier decree, kindly see, page 6, I was placing, they did not, 7.1, 7.2 was also not filed there. Therefore, this cannot, act as a res judicata in the present suit, where, a fresh eviction suit has been filed on a fresh, after giving a fresh, eviction notice. 7.2, 7.1, C,
Okay, hard. You give me the special court judgment. Do you have the copy?
Kindly comes to paragraph 20 onwards. No, not 20, my lord. Paragraph 15, my lord. Paragraph 15. My lord has my lord is kind enough to come to my lord the first page of the order. What was the question before the special bench? Is civil revision and application?
Yes, I know that.
Yes, the moot question, the third line. Moot question involved in the application is whether the court can extend the time for depositing admitted area rent together with statutory interest as provided in 7(1) of the West Bengal Premises Tenancy Act 1997. Here, my lord, it was filed, but no extension was sought for. Here, my lord, there is no filing at all. My lord, I am on a better foot. Then, my lord, kindly comes to, my lord, paragraph 15 of the judgment. My lord has got it, my lord. It starts with the word the Honorable Apex Court took note.
Yes.
The Honorable Apex Court took note of the decisions rendered in BP Khelka, such and such, and arrived at the conclusion that the tenant would not be able to take recourse of the provision of Section 5 of the Limitation Act. The Honorable Supreme Court noticed the decisions in the above cases and still arrived at the conclusion that filing of the applications and deposit, payment of the admitted areas with statutory interest within the aforesaid period were both mandatory preconditions to be complied by a tenant to avoid eviction. But this is mandatory. We proceed to discuss the ratio in Amit Kumar Chavaria Supra on institution of a suit by the landlord or eviction of any of the grounds referred to in section 6 of the said act. The tenant subject to the provision of subsection 2 of section 7 was liable to pay to the landlord or deposit with the civil judge all areas of rent calculated at the rate at which it was last paid and up to the end of month previous to that in which the payment was made together with interest at the rate of 10% per annum. Such payment or deposit was to be made within 1 month from the service of summons to the tenant, or where the tenant appeared in the suit without summons being served within 1 month for his appearance. But this is where I am harping on, because 31st May he was added. Therefore, he had polished the suit as of 31st May. Therefore, the tenant was enjoined by law to continue to pay to the landlord or deposit with a civil judge a sum equivalent to the rent at the rate month by month within 15th of each succeeding month. In case of any dispute as to the amount of rent payable by the tenant was liable to deposit with a civil judge within the time specified in the subsection the amount admitted by him to be due from him together with an application for determination of rent payable. No such deposit could be accepted unless it was accompanied by an application for determination of the rent payable. On receipt of the application, the civil judge, having regard to the rate at which the rent was last paid and to the period for which the default may have been made by the tenant, determine the issue, the dispute, and pass an order within a period not exceeding 1 year, specifying the amount in, if any, due from the tenant, and thereupon the tenant was liable to pay to the landlord within 1 month from the date of such order the amount so specified in the order, along with the monthly rent at the rate so determined. Moreover, the decision in Bahadur Singh Katua Supra was rendered without considering the decision of the division bench of Calcutta Gujarati Education Society versus Ajit Narayan Kapoor passed in such and such. The Honorable Division Bench answered the reference in view of the conflicting decisions of the division benches of the court. The question was formulated by the acting Chief Justice was as follows. Then it was as court speaking over. Then we got paragraph 18. The reference was whether section 5 of the Limitation Act would be applied to condone the delay in filing the application and the subsection 1 of section.
Altogether separate issue is there, I know.
Why not? Section 5. Whether that can be condoned.
That is the altogether separate issue.
No.
It was not there in the.
Yes, it was. I want to say that you have to file.
At least there may have an application.
And that too.
The only issue is that why disallowing your prayer that the issue has been settled or decided by the court on the earlier suit.
That is
but
a
that was
completely wrong finding.
Yes.
I have placed it before your lordship.
Very hard. Heard.
Completely wrong finding.
Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Full stop. Next paragraph. Despite service, none appears on behalf of the opposite parties. Full stop. Next paragraph. The instant CO has been preferred against an order dated 27/6/2024 passed by the learned First Court of Civil Judge Senior Division, Howrah, in title suit number 127 of 2023. The brief fact of the matter is that the plaintiff, being a landlord, filed a suit for eviction of the defendant from the disputed premises on the ground of defaulter. It is the case of the plaintiff that the defendant, after appearance, has contested the suit by filing written statement. But till date, they have not preferred any application under section 7 within bracket 1 WB or 7 within bracket 2 of WBPT Act 1997. Hence, the plaintiff petitioner has filed an application under section 7(3) within bracket 3 of West Bengal Premises Tenancy Act, WPT Act 1997, for a necessary order to strike out the defense of the defendant for non-compliance of mandatory provision under section 7(1) and 7(2) of WPT Act. Full stop. Next paragraph. The learned civil judge concerned has heard the petitioner and the defendant stroke opposite party full stop. The learned civil judge concerned, by passing the impugned order on 27/6/2024, has turned down the prayer of the petitioner under section 7(3) of WPT Act on the sole ground that the same question has already been decided by the court in title suit number 397 of 2016. So, the question of struck out of defense of the defendant has already been decided by passing the judgment in the earlier suit. Full stop. For the learned advocate for the petitioner, peruse the judgment passed by the learned Court of Civil Judge Senior Division, learned First Court of Civil Judge Senior Division, Howrah, in title suit number 397 of 2016 on 26/7/2022. on plain perusal of the judgment, it appears that the suit was dismissed on the ground that plaintiff fails to prove the fact of induction of the defendant number 2 as tenant over the suit premises. As such, the landlord and tenant relationship was not proved. Full stop. The said suit was dismissed on 26/7/2022. It appears that it appears from the paragraph 9 of the plaint of the present suit within bracket TS 127 of 2023 that the cause of action arose in this suit on 18th December 2022 when a notice to quit was served upon the defendant through registered post. Thus, it appears that the cause of action of the instant suit arose after the disposal of the said suit being number 396 of 2016. Thus, it appears that the observation of the learned civil judge concerned regarding the disposal regarding the adjudication of the same issue in the earlier suit is not correct. Full stop. Next, it further appears that the provision of 7(1) and 7(2) of West Bengal Premises Tenancy Act has provided a protection to the tenant against the proceeding of eviction. Full stop. A defendant stroke tenant has to opt the provision enumerated under section 7(1) and 7(2) of the WPT Act 1997 for getting benefit against the protection by the landlord. The issue has been well settled. No, full stop. In this case, it appears that the defendant number 2 was added in the said suit on 31st of May 2023 till 23 within the stipulated time framed under section 7(1) of WBPT Act. The defendant never applied for filing admitted rent to the court or did not file any application for settlement of the rent by the court. Thus, in my view, the application under section 7(3) of the WBPT Act 1997 filed by the present petitioner stroke plaintiff is quite meritorious. However, the law has been declared to that effect by the Honorable Supreme Court in Vijay Kumar Singh versus Amit Kumar Chamaria within bracket 2019 bracket close 10 SCC 660 as follows. করে টেনে দাও এইখান থেকে 19 এই পেজের এই জাজমেন্টের 14 নম্বর তারা আছে এখান থেকে শুরু করতে হয়েছে according to the observation made herein above, also according to the dictum of the Honorable Apex Court in Amit Kumar Chamaria Supra, I am of a view that the application under section 7(3) of West Bengal Premises Tenancy Act 1997 filed by the present plaintiff stroke petitioner is justifiable. The impugn order passed by the learned civil judge concerned is hereby set aside. Full stop. The defense of the defendant number 2 defense against by the defense of defendant number 2 against the delivery of possession be struck out full stop. Under the above observation, the incident CO is disposed of. Full stop. Next part. The learned civil judge concerned is to proceed with the suit according to the law and dispose of the same as early as possible, more preferably within 6 months from the date of passing of this order. আচ্ছা একটু আগেরটা কি বললে তুমি বলো ওই জাস্ট আগের প্যারাটা কি বললো করে দিলে by the plaintiff petition justified and allowed. তারপর কি বলি সেটা কমা করে দাও ফুল স্টপ করো তার প্যারা করে দাও ঠিক আছে
Like the book, my lord.
yes
Okay.
In this matter, I got a petition I am led by Mr. Amit Kumar Paul and filing the affidavit in opposition against the application for addition of party matter.
করবেন না আপনি আছেন
তুই তো ওদিকে তো
তুই আছিস পারবেন
আমার
মামলা শুনে বুঝতে পারে কে পিটিশনার কে রেসপন্ড
তুই ওদিকে যা
লেখার দরকার হয় না
তুই ওদিকে যা
তাই তো
আপনি address করুন।
This is my application for addition of party and for vacating of the ink. Just to recapitulate, my lord, I just get
No, you have filed the application for
for
addition of parties.
and for vacating of it.
কোথায়? এটা বলো।
This is can 7.
বলো, no application is of
আরে
vacating the
প্লিজ
entry
আমি
order.
আছি তো
না, এটা appropriate order.
প্লিজ একটু বলতে দে তুমি যদি বলো তাহলে বসো
রাগ করবে।
তাহলে বসো
Can 7.
So the matter was taken up for hearing. A point was taken that it is a not application. I said it's a composite application for appropriate order. The point. My lord, may I?
Yes.
Can my lord recall that you are relying on a judgment of your lordship where your lordship was pleased to dismiss the writ petition on the ground that it became infructuous. Why infructuous? 2010, my lord, MR dealership was published. In terms of that vacancy, some candidates participated in that. According to some candidates, there are illegalities. They filed writ petition. Writ petition with interim order was pending. Well, I will not take when it was extended because I am going to the main question, not in the ancillary question. In that writ petition, my lord, interim order was passed. I was not parties, I was not known to. Thereafter, my lord, Food Security Act came into. According to my humble submission, the moment the Food Security Act came into force, all previous vacancies, all under the old act, goes. So far as where I am now, the dealer, MR dealer, a notification was published. Vacancy was declared. I participated and selected, started working. 2 years I worked. One fine morning I found that a writ petition prior to Food Security Act came into force was pending. There was an interim order. Now the writ petitioner here in this writ petition filed a contempt application, saying that in the teeth of the contempt, the interim order, the vacancy could not be published, and my candidature was my dealership was cancelled. When I came to learn of this, I have no other alternative but to apprise your lordship that the interim order which was, even if it is subsisting on that date, that became infructuous in view of the subsequent enactment. This is the subject matter of challenge. Kindly come to.
No, so in you have filed addition of parties in
And for appropriate order. In
and
this
for-
writ application.
in this writ application, the writ application which was filed for prior to the for the earlier vacancy for the earlier vacancy.
Earlier.
Okay.
This is the short and subject. Now kindly come to page 11. So this is 2014 vacancy declared. As my lords kindly got it. Kindly turn over the page. Your lordship will get item number 3. Whole food subdivision. Key number that is. Nanur. As my lords kindly got it. Page 12.
Yes.
So this was the vacancy which was subject matter of challenge in this writ petition. Now my lord kindly come to page 14. The interim order. The nature of the interim order is, my lord, required to be read in this practice. Since a similar matter, this honorable court has not applied his mind to this application. There is no specific order on this. What his lordship was of the opinion, since in similar matters repeated interim order has been passed, let there be an interim order directing the respondent not to appoint any MR dealer for the vacancy concerned in the village Nalur, Birbhum, such and such, or until further or whichever is earlier. Vacancy concerned and not independently decided this matter on the basis of the earlier other writ petitions, this interim order was passed. I am giving emphasis on this word, the vacancy concerned. Vacancy concerned has been stated. Now, my lord, kindly come to 16. Now, my lord, kindly come to page 16. Now, you also have to consider what is the implication of the notification. In view of the implication of the National Food Security Act 2013 in the state, the governor is pleased to cancel with immediate effect the FPS vacancies notified by memo number such and such and such and such, dated 20th January 2014. I have just now shown to your lordship. 20th January 2014. As well as got it at page 11.
Yes.
Cancel. No further action will be taken in connection with the application received against such vacancies.
Yes.
Now, my lord, my submission in this context is the Honorable Justice Pal, as the Lordship then was, passed an interim order in respect of the vacancy. The vacancy, which was declared in 2011, has given a complete overriding effect of this 2015 circular in view of the statutory provision enacted in the meantime. Then you will also consider what is the effect of the interim order which was subsisting, even if it is subsisting on that day. Then, my lord, it is a judgment, my lord, where the earlier all vacancies which the subject matter writ petition was pending, and the order of 17th August 2015 was subject matter of challenge. I will not trouble your lordship, is reached up to Supreme Court upholding the notification of 17th August 2015. So new vacancies has to be declared, and accordingly it was declared. I participated, selected. He was not the participant even.
So now your prayer is to make a party here, to add a party here.
Party and to vacate the interim order. According to me, it is informal order because interim order is no more subsisting. What is to be vacated?
But that has to be considered after hearing the merit of this matter or otherwise.
And this is the merit.
Let you admit in the matter.
No, I am submitting, my lord. If I consider this along with the merit, what is the merit? Merit is the interpretation of 17th August 2015.
I understand.
Nothing more. I will not make any submission. If 2015 circular holds the field, then
your prayer is not there to pass any just appropriate order like that. I just want
appropriate order, my lord.
Otherwise, if it was challenged, it would be otherwise. You know the issue.
My lord has read that portion.
Yes.
It says please to implement and for proper appropriate order. This is omnibus prayer.
That's why I am asking you. You may have the.
I cannot develop that. What is there? But implication of this application is very simple. Interpretation of 2015 circular, which has been upheld up to Supreme. And what is the effect of that? Only on that ground, the interim order, which is infructuous in nature, was subsisting. After working for 2 years, all of a sudden it was cancelled because of the threat of contempt. Now, my lord,
it was cancelled.
Yes.
Have you challenged the cancel?
No.
You have not challenged it.
Because it is the effect of the contempt.
So that is altogether separate issue. I am not going to.
If today your lordship is pleased to hold that there is no interim order subsisting in the matter, or this matter is dismissed, if allowed, my cancellation will uphold. But if the writ petition is dismissed, then my cancellation will automatically go. Because this is cancellation is not for any other thing. Only on the ground that as if an interim order was subsisting and the authority cannot appoint it.
No, you cannot want an order from this court which can allow you to.
I not ask to do that, but you know my limitation. I will only show to your lordship that whether the writ petition can survive.
Okay, that is the altogether separate issue. Okay.
No, I don't ask for that. They kindly allow me to continue.
Okay.
If the writ petition survives,
on death. If it is death, I will survive. If it is survive, I will die.
Very good.
Now, my lord, another two things I will show to your lordship. The appeal also gone. Supreme Court affirms. Can you see the Supreme Court's order, page 52
Now, where is the order of this court?
of this court? This court order is at page 16, 17. The longest order.
17.
17 is start. Okay. My lord, if it is correct, my lord, your lordship, if you logically look to page, page 18, your lordship will find what is the subject matter of challenge. The state by the input notification dated August 17, 2015 seeks to withdraw the selection process in view of the provisions of 2013 Act, which I am repeating here. This was subject matter of challenge. Justice Poshak, my lord, affirmed the contention of the state. I got that order. Subject matter challenge you want to show, nothing else.
Yes.
Now, my lord, it was appealed against. Page 21 is the appellate order, the longest one. And page 52 is the reported judgment on HCC online. The orders of your lordship court has been affirmed. Also will find, my lord, page 58. Division bench was other contrary view. The Supreme Court affirming, my lord, kindly come to page 58. In terms of the order passed by this court, these appeals are also allowed and the judgments of the division bench impugned herein is set aside and the judgment of the learned single judge dated such and such is restored.
Yes.
Well, I've seen that. So, none can say that in spite of the promulgation of 2013 Act, any vacancy which was there is subsisting. Now, my lord, what is my cause of action? Page 64. Can you see my predicament? Can you see my luck?
Page 60.
64. This prompted me to approach your lordship. In pursuance of the solemn order passed by the Honorable Justice Raja Basu Chaudhary, in Honorable such and such, is hereby cancelled because that is remote. The contempt petition was moved before Justice Chaudhary.
Your license is at page 62.
License at page 60. Justice. Normal license. Yes, this is my license. I was running for at least for 2 years. Probably. Here about 2 years I was working. And the last 2 years, he never approached the authority, the writ petitioner, that yes, there is subsisting interim order, why allow him? All of a sudden, he approached the contempt proceeding, and honorable judge has no other alternative in a contempt proceeding than going to the merits of the matter. So he has lordship has to only to see whether there is interim order or not. Now your lordship's order. I handed over already to your lordship the judgment passed by delivered by you, my lord. This is Dalur Rahman, WPA 23291 of 2015. That's the copy. Kindly, as well as got it, your lordship judgment. We file it.
Thank you.
Lutford, Dalur Rahman. Dalur Rahman. If I read below 2 paragraphs, it will lordship will come to lordship mind. Starts with an advertisement was published on 21st February 2014. Hearing memo number such and such, Gaurampur such and such. The present petitioner applied for the vacancy and necessary formalities regarding the license has been conducted by the state authority. The inspection was held at the site. It is the case of the present petitioner that after such inspection, the state authority has issued a correspondence for enhancement of the bank law such and such. Suddenly, after completion of such formalities, the state authorities kept themselves mum, and thereafter, suddenly, it issued a notification on 17th August 2015. That notification. So earlier, proceeding was initiated, to some extent completed, but kept themselves mum. Then this notification is published. Their contention was in this matter that how you can stop me? You have already started the process. Now suddenly after this notification you cancel everything. That your lordship was pleased to afford. That yes, the Food Security Act came into force, the statutory enactment. So it is valid. The government was correct. This is the order. Point was that.
Yes.
After enactment of central enactment, whether previous vacancies were subsisting or not. This was the point canvassed before my lord, and your lordship, on the basis of Supreme Court judgment and the honorable single judge's judgment, your lordship uphold the contention. Now it can be done.
Okay.
I'll be paying the same relief in this writ petition also, because this writ petition and the writ petition which my lord has disposed of are on the same footing. So my lord, one judgment I want to sign. This is reported in 2003, one Supreme Court cases, 7 to 6. But I am a bad habit of marking when I read.
Very good.
I think this will help people of one look to this. I will hand over Xerox copy. These are the properties, sorry, but six. Why I am relying this? Sorry.
Yes.
Why I am relying this, my lord? Can you visualize the situation? When the writ petition was filed, he has a cause of action. Because on that day, the central act cannot come into force. He has a right to sue. He is proceeding with this matter. Court has right to decide that on that issue only. In view of the subsequent event, his relief may be infructuous. That Supreme Court says the Honorable Court, while deciding the petition, can take into consideration. No, my lord knows a suit is filed on the basis of a cause of action.
Yes.
Your right, which was crystallized on the date of filing of the suit, has to be decided. This is the exception carved out. If the subsequently something happened which may make your writ petition or the suit infructuous, court can look into it and render this writ petition or the suit non-est. This is, my lord, my submission. In the affidavit of opposition, my lord, he has not said anything against me. Even he has not said why he was mum for 2 years when I was working to approach them that in the teeth of the injunction, vacancy has been declared. He has not said anything. Nothing said. It was known to him the vacancy has been declared after 2015. He has not approached your lordship's court in a contempt proceeding. But this is an untwisting litigation. Now, for the first time after 2 years, we approach the contempt proceeding. That's what.
Yes.
May I have a copy, xerox copy of that?
You need to push it. My lord, I am opposing this. Possibly,
Yes.
my lord, your lordship is not going to decide my writ petition on merit. First of all, he has to establish that he is a proper and necessary party in deciding the issue involved in my writ petition. That is a settled principle of law. Laws settled by the Supreme Court. Now, my lord, what is the statement that has been made in the application for addition of party? Now, before that, neither he was participated in the 2010 when I was selected, nor he was participated in 2014 vacancy, which injunction has been sought for and injunction has been granted. In both the cases, he was not the party. An issue before this honorable court, I may have a very bad case. But he is not a necessary party for the purpose of deciding the issue. And so far the interim order is concerned, state has filed an vacating application that is pending adjudication of this honorable court. Until today, in my writ petition, state has not affirmed any affidavit. Use an affidavit is part of several direction. Contempt application is pending. Now, my lord, you kindly see, I am surprised that how he can continue with this. He said candidly that 2 years he is continuing. I don't know how. Why I am saying this? Kindly we turn to page 59 once.
59
of their application. Page 59. And possibly, my lord, next page I will come. Page 59, relevant page, page 60, page 60, relevant, this is the license, I understand. Page 60.
Because my learned friend was referring to page 62, but I understand this is the license at page 60. Now kindly turn to the next page. Clause 13. Clause 13. This license shall be valid up to 31st December 2023. Now there is no averment or not a whisper that subsequently this has been extended. And next page, my lord, I don't know your lordship's copy is legible or not. So far I was served with the application, my copy is illegible.
Communicated to my learned advocate because this is the practice.
Well, this is the, my lord, this is the thing. I have been served, it's an illegible copy. So possibly in your lordship's copy, your lordship will maybe possibly that is appearing that whether I am incorrect to say that license was expired on 31st December 2023.
In page 63, the license was valid up to 31st of December 2026.
Page 60, I don't know.
This is the
There,
page
because
63.
it's a very surprising. Then may I put it to myself, since my copy is illegible when this 62 came into effect. After if it is after 1st January 2024, there cannot be two sets of license. Because he is heavily relying on this page 60. At least from this averment.
Yes.
Because I'm not in a position to say submit on anything because kindly have a Joseph within it. Kindly have a look at my copy.
Then you have a fresh copy.
The practice is we are contemporary. Practice is if I am getting an illegible copy, I should comment. I was communicated to the other side that this is illegible, can you supply? Or oral, we supply. Not to blame me for the court.
Okay, just he is arguing on that the copy that this is not legible. So you have to serve a legible copy at least. Yes. So what is the issue involved in your read?
Yes, my lord, in my read petition, what is the issue involved and how he is a necessary party? My lord, in my read petition, I was recommended as a first candidate in terms of a vacancy declared in 2010. Till today, that vacancy has not been cancelled, either by any authority, till today. In spite of the coming into force of the act in question.
It was not declared?
Well, not a single document, at least I do not find this. By not a single document, the vacancy which was occurred in 2010 and that has been cancelled. All other vacancies has been cancelled, my learned friends shown to your lordship. But 2010 notification was never been cancelled. In my writ petition, what I have challenged before this court, because my lord, I was recommended as a first, and this was sent for the director of controller for approval. That was pending. Now, during pendency, another vacancy was declared. 2014. I challenged that action and got an interim order. In 2014, when I moved this court, he was not a necessary and proper party. So in deciding the issue, whether that vacancy in 2014 vacancy was correct or not, that is the issue to be decided by your lordship. And at that juncture, at any stage of imagination, it can be said that the applicant is a proper and necessary party in deciding the issue. He might have any other cause of action. He might have other action. He can take any other steps against his cancellation. But in an application for addition of party, possibly my writ petition will be adjudicated. I have never heard of.
আমি যখন থেকে শুরু করবো না তখন তো যখন শুরু করবো না তখন তুই না টিকতে পারবি না, আমি দেখছি তো তোকে আমি একটাও ডিস্টার্ব করিনি, কিন্তু তুই একটা কথা বলবি না।
আমি বলে শোন এখন।
And my learned friend is saying that when this vacancy was declared, I was keeping idle. No. Immediately I take steps against this. I'm filing contempt application. And being satisfied with the contempt, rule was issued. And that is pending adjudication. Moreover, my lord, the identical issue, state has prepared an application for vacating application and recalling the order. And that is pending adjudication. So under any stage of imagination, it can be said that the applicant is a proper and necessary party in adjudication of the issue involved in my writ petition.
So in your writ petition, you have challenged the pray for quash.
Yes.
Of the notification issued on 31st of January 2004 in pursuance of approval.
14.
No. In pursuance to the approval of Government of Food and Supply Department by memo number 20 of January 2014.
Yes.
চলে গেছে।
Your Lordship will find my pair in the writ petition at page 17. And in that notification, he has not participated. If I am wrong to, if I am not wrong to say so. So the issue, whether that notification was correct or incorrect, or legal or illegal,
yes,
he cannot be a necessary and proper party to that. And more interestingly, my lord, what I find that he was called in the office by an inspector and handed over the cancellation letter over phone. I don't know, my lord, can it be a way of serving notice for cancellation? In his petition, he has candid, he is very much candid to say this. And if this cancellation letter is bad in eye of law, taking into consideration the order of the Honorable Supreme Court, then he could have challenged this in a separate writ petition. But in my writ petition, which is issue is completely different altogether, he cannot be a necessary and proper party in deciding the issue involved in the instant writ petition. Well, to this, the judgment. Subject to your lordship kind consideration. If you let's say this is I am writing a judgment reported in my lord in 1963 Supreme Court. Yeah, 1963 Supreme Court 786. Paragraph 7. He may have a very good case, but cannot be decided his rights altogether in my writ petition. And at his instant, my interim order cannot be vacated. And
You are referring paragraph?
Paragraph 7. This is in the allotment in for a liquor shop. Similar issue was raised before this honorable the honorable Supreme Court. To answer the question raised, it would be convenient at the outset to ascertain who are necessary or proper parties in a proceeding. The law on the subject is well settled. It is enough if we state that the principle, a necessary party is one without whom no order can be made effectively. A proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision on the question involved in the proceeding. Now I shown to your lordship, my lord, what is the issue pending before this in my writ petition, and they never applied for in those on those parties 2010 or 2014 they participated in the proceeding. So issue involved whether 2014 notification can be issued pending disposal of my approval. That is the issue involved in my writ petition. For deciding that issue, can it be said, my lord, they are the necessary and proper party? And in absence of them, no adjudication can be made.
You have also prayed for issuance of license at the site at village Nanur.
Yes, because I was selected first. That is my pleading.
That is altogether.
So that is the thing, my lord, that was pending approval. That was pending approval of the district controller. That was my cause of action. Either you have to reject it or you have to approve it. My case was you cannot sit tight over the matter.
So your case was that you were the selected candidate.
Yes.
But subsequently state had issued a notification which you have challenged.
My lord. And in 2010, this is not their case that they participated, or 2014 they participated. So the issue involved in the petition, they are not the necessary party. If his application has been, license has been cancelled in violation of the order of the Supreme Court, settled principle of the Supreme Court, he could file an appropriate application against that. Or I will not advise to them, my lord, if they are aggrieved by the interim order, they could pay for an appropriate steps against that also. But not my way of an application for addition of party, wherein they have sought for rejection of the vacating of the interim order. So, my lord, this application may be rejected. And so for the merit of this application is concerned, my lord, until and unless, my lord, this application is allowed, the question of deciding going into the merit of the writ application. So, my lord, for the purpose of merit of their application for addition of party, they don't have any merit, my lord. They are not the proper and necessary party in the instant application. And moreover, my lord, state has an application for recalling application. Whether my application has become infractuous in that will be taken care of in the time of hearing of the writ petition. And if it is become an infractuous, they could have preferred an appeal. They could have taken steps against the cancellation, ventilating all their grievances, but not in my writ petition.
legible copy দে না তোদেরটা।
Yes.
I'll not take much time, my lord. I have only two full
I have twofold submission. One is that it is the state's contention, my lord, that the writ petition has actually become infructuous. But I cannot agitate that point, as Mr. Pan rightly says, my lord, that it has to be adjudicated at the final stages of the hearing. Second is that, my lord, either way the writ petition is decided, my lord, if it is held that the writ petition has actually become infructuous, then, my lord, the license, which by virtue of the interim order, of which the state has also filed a recalling, the license today stands cancelled as far as my learned friend's client is concerned. If the writ petition is held to be infructuous, then that license automatically gets revived because the contempt, etc., my lord, is to be disposed of accordingly. If it is held that state's contention is not correct, then, my lord, the cancellation remains. Therefore, either way, the applicant will be affected, because in one village, the state cannot give two vacancies. There has to be only one dealer, my lord, after seeing the viability.
Yes.
So, the way I look at it, my lord, either way, the applicant will be affected by the order passed in the writ petition. Therefore, my lord, no harm will befall anyone if the applicant is there as a respondent before your lordship. Now, my lord, that the argument made by Mr. Pan, my lord, though I am not replying to his argument, standalone, I am trying to make my own argument, my lord. The case of the writ petitioner is that in 2010, there was a vacancy declared. In 2011, he participated. According to him, like in many petitions it is written, according to him, he was the most suitable candidate. The comparative chart, etc., also said that he was the most eligible candidate. But no finality was given to that recruitment.
Selected.
He was ultimately not selected. In 2014, another recruitment process is started, which he challenges, saying that my earlier recruitment process has not been completed. Therefore, I, being the most suitable candidate, I have a right. This 2014 recruitment process, my lord,
I was selected. Not for
No, shortlisted.
Selected.
Shortlisted.
I was number one that was required forwarded to
No,
the district
your-
order for recommendation. Recommendation was forwarded to for approval.
No, your writ petition is not saying that you have been selected like that. I have
my lord,
read the writ
By
petition.
this time,
my lord,
member of the procedure in the charitable matters, if recommendation goes, thereafter finality reached.
my lord, my lord, I can read, my lord, the entire pleading from the contempt application for Mr. Pan's benefit, my lord, but he has not made out that case. My lord, in the addition of party application, my lord, if your lordship kindly takes page 11,
Yes.
I am only on the point of affectation of the applicant's right apropos to the decision in the writ petition. And in aid of that, I'll only show 2-3 pages. Kindly take the application, page 11. First paragraph, your lordship has got, my lord. First paragraph, last line. In the district of Birbhum, Vide, memo number kindly notes, my lord, 152 FS dated 20th of January 2014.
Page 11.
Page 11 of the application. Page 11 of the addition of party application. But it's a memo dated 24th of January 2014.
24th of January 2000.
Can you take the first paragraph?
Yes.
The undersigned is directed to inform him that the government in food supplies has accorded approval of a declaration of fresh resultant vacancies of MR dealers as mentioned in Annexure B in the district of Birbhum, Vide. Kindly marks, my lord, memo number 152 FS dated 20th of January 2014. So this is the approval by which the declaration is made in 2014, which is under challenge in the writ petition.
Yes.
Because this is 24th January is under challenge in the writ petition. This flows from 20th of January 2014. Now, kindly comes to page 16. Page 16, madam. Well, my learned senior has already placed it. In view of the implementation of the NFSA in the state, the governor is pleased to cancel with immediate effect. Then kindly skips 2 lines. 152 FS dated 20th of January 2014.
Yes.
Your lordship will get it in the 5th line.
Yes.
Therefore, this cancellation of 17th of August 2015 was challenged up to the Honorable Supreme Court, where the state's contention was accepted by the Honorable Supreme Court in Gitosri Datto, that this cancellation is apropos to the NFSA. Therefore, the cancellation is upheld. There is no doubt about it. Up to the Honorable Supreme Court, the cancellation of the vacancy declaration is upheld. Malad, whatever is the declarations under the 20th January 2014 are also cancelled. So, my learned friend's contention that my challenge is still surviving, it is impossible. It is impossibility in law, because the vacancy is erased from the records by virtue of the decision of the Supreme Court. So he has no challenge left in the writ petition. But this, I'll have to argue in the final stage to make a point that the writ petition become infructuous.
Yes.
But I come back to my point that whichever way your lordship decides, there will be an affectation of right, because of the pendency of this writ petition, because of the interim orders passed in the writ petition, because of the alleged violation of those interim orders, a contempt is pending. By virtue of that contempt, we have cancelled his license today. So if it is to be revived, the writ petition has to be finally decided. So, if I may put it in this way, my understanding, it is not my prayer before lordship, my understanding of the situation is that the applicant should be added as a party and kindly hear the writ petition finally, with him added as a party.
What is the can 6?
Can 6 is my application for recalling of the interim order, which is for vacating of the recalling of the interim order, which is pending before another bench, because it's a recalling of another bench's order.
Okay.
Therefore, by virtue of determination, it is before another coordinate bench.
One sentence, Mr. Pans. He is absolutely correct, because we are the same civil chamber.
Yes.
That when the writ petition was filed, I cannot be a necessary party. Because where I am, I was nothing to say. I had not participated, nothing. After the 10 circumstances which are relied on Supreme Court judgment, my affectation is the first thing which prompted me to revive this of a dead situation. Because as my lord understanding said, I have submitted in terms of Supreme Court judgment, this writ petition became infructuous. My lord had decided, sitting singly.
Very okay. Hard. I shall pass the order.
I need to mention one matter.
Order order.
No, I shall pass the order after the at 2 p.m.
Great.
Today. 2 p.m. কিছু ফিক্স আছে? আছে মানে এটা বলে দিই তারপর করব। After the judgment I'll pass. Yes, what is the matter mentioning?
My lord, the petitioner is a dependent widow of one deceased MR dealer, and she has applied for transferring the MR dealership license from her father-in-law to her name. Without deciding her application, the department has issued new notification for appointing new MR dealer.
So why you are here? Have you filed any writ petition?
Yes, I have already filed, my lord. If it is not decided, then they will select the
whether it is listed.
Yes, it is in 29 in today's list, my lord. If it is not coming in today, then if you kindly take it up tomorrow, it will be highly exceptional.
It will be listed, then it will be taken up today or tomorrow.
Yes, if it is not reached, my lord, today, then kindly take it tomorrow, my lord.
It will be there in in the list.
Obliged, my lord.
Okay, please take down. And 7 of 2024. This is an application for addition of parties and for appropriate order. Learned counsel appearing on behalf of the applicant submits that the present applicant was selected as a successful candidate in respect of MR license at village Nanur under Borpur subdivision. Village Nanur in the district of Birbhum. He submits that a license was issued in favor of the applicant the said license was extended up to 31st of December 2026. Subsequently, it came to subsequently his license was cancelled by the concerned SCFS with a memo dated 25th of September 2024, citing the fact that by the order of coordinate bench of this court in CPAN number 808 of 2023, CPAN number 808 of 2023, read with WPA number 6527 of 2024, 2014. The said license was cancelled. due to pending adjudication. Full stop. It is the case of the applicant that the present petitioner applied for the vacancy applied for the earlier vacancy notification dated 25, applied for the MR license in respect of earlier notification dated 21st September 2010 for the 21st September 2010 for the location at village Nanur in the district of Birbhum. The case of the petitioner before this court that on subsequent notification dated 31st January 2014, the earlier notification dated 21st September 2010, in which the petitioner was applied for vacancy was turned down. In which the present petitioner was applied for vacancy was turned down in terms of implementation of National Food Securities Act 2013. It is the case of the applicant that one interim was passed by the cornered bench in the instant writ petition, though the matter has been settled by the Honorable Apex Court. But as the petitioner has applied, has filed an application for contempt, the license of the petitioner license of the applicant was cancelled by the authority concerned. Mr. Saptangshu Basu, learned counsel, appearing on behalf of the petitioner, submits that the instant writ petition has no merit to determine only due to the existence of an interim order, which is not at all subsistence, and further due to the filing of an contempt application, the license of the present petitioner was cancelled. He submits that the present petitioner is a necessary party in the proceeding, so he may be allowed to participate in the proceeding. Next, Mr. Basu further urges that the merit of the instant writ petitioner has already been decided by the Honorable Apex Court in several decisions, this court has also passed orders in pursuance to the order of the Supreme Court. So there is nothing remain to decide in the writ application. Thus, necessary order may be passed so that the interim order passed by this writ petition, interim order passed in this writ petition may be vacated and the writ petition may be disposed of. Full stop. In support of his contention, Mr. Basu has relied a decision of Honorable Supreme Court in Beg Raj Singh, BEG, Beg Raj Singh versus State of UP and others, within bracket 2003, 1 SCC 726. এটা কোট করবেন, পেজ 2727 এইখান থেকে Mark portion. Next para, citing the principle of law, Mr. Basu has argued that the subsequent fact may be noted down by a court in deciding a writ petition, and if it appears that the relief as prayed in the writ petition has no existence due to the subsequent event, the writ court can very well dispose of the writ petition, noting the subsequent event. Mr. Pan, learned counsel, appearing on behalf of the writ petitioner, raised strong objection and submits that the present applicant is neither a necessary party nor a proper party to the instant proceeding. He submits that the challenge of the writ petitioner may have no right footing at present, but the applicant do not have any right to intrude himself in the instant proceeding. Full stop. He submits that the present applicant neither applied for the vacancy in the year notification in the year 2010 or in the year or in the vacancy notification in the year 2014. Thus, he has no right to challenge the notification dated 31st January 2014, which was challenged in the instant writ petition. Full stop. He submits that the participation of the present petitioner is not at all required to determine the issue involved in the writ petition. Issue involved in this writ petition. Mr. Pan has cited a decision of Honorable Supreme Court in Udit Narayan Singh Malpahadia versus additional member Board of Revenue, Bihar, the 1962 SCC online SC 130, paragraph 7 thakur. Or the learned counsel, no. Mr. Shishanu Bandyopadhyay, learned counsel, appearing on behalf of the state, submits that the license of the present applicant has been cancelled due to the pending litigation of a content application being CPAN 808 of 2023, arising out of an interim order passed by a coordinate bench in this proceeding within bracket in this writ petition proceeding in this writ petition bracket WPA 6527 of 2014. Mr. Bandyopadhyay has categorically argued that the writ petition, that the instant writ petition has no merit to entertain However, for as there is an order of as there as an interim order was existed in the instant writ petition, comma, the contempt application was filed. It submits that the present applicant was granted license in respect of the Emma dealership at village Nanur under district Birbhum. So he is the necessary party in this process. Or the learned advocate peruse the application being Can 7 of 2024. I have also perused the grounds mentioned in the grounds and pleadings of the instant writ petition. It is the case of the writ petitioner that he applied for vacancy in respect of a memo of concerned SCFS dated 21st of September 2010. Full stop. It is the case of the petitioner that the memo was for issuance of license of Emma dealership for filling a vacancy at village and post Nanur under district Birbhum. Full stop. It is the case of the petitioner that he was the most suitable candidate for the said vacancy notification dated 21/9/2010, but the concerned authority during the pendency of the said selection process has issued a subsequent notification dated 31st of January 2014. Thereby, the earlier vacancy notice dated 21/9/2010 was cancelled. He challenged the notification dated 31st January 2024, 31st January 2014 in the instant writ petition. He also prayed for issuance of license of Emma dealership in favor of the writ petitioner at village Nanur. Full stop. It is true that the notification whereby the state authority has cancelled earlier notification by virtue of implementation of National Food Security Act. এবার বলুন তো কি বললাম এটা? It is true that notification dated করুন 17/8/2015 whereby (2013) has been approved by the Honorable Apex Court in a separate writ petition. Full stop. it further appears that the state authority has also filed an application before this court being Can 6 of 2024 for recalling and stroke or modifying the interim order passed by this court. Full stop. However, to determine all the issues, it appears to me that truly the challenge in the writ petition by the petitioner is about the challenge of notification dated 31st January 2014 and the act of the government authority in issuing such notification. It is also true that the present applicant was not at all party to the party or any of the party stroke or any of the applicant in the earlier notification dated 21st September 2010, but facts suggest that the applicant was appointed as a MR dealer in the village Nanur under district Birbhum. The instant writ petition also filed challenging a notification, challenging a vacancy notification in respect of the same location, in respect of the same village Nanur under district Birbhum. Full stop. The interim order passed by this court by a coordinate bench in this writ petition, by a coordinate bench in this case, in this writ petition has decided the right of continuance of license of the petitioner, of the applicant at village Nanur. Thus, in my view, though the present applicant is not the necessary party to the lease or the issue to be decided in the instant writ petition, but the result of the instant writ petition may very well affect the right of continuation of license of the present applicant. Thus, he may be a proper party in the instant proceeding. Under the above observation, I am of a view that the present applicant, being a proper party, is entitled to add as a party in the proceeding. Thus, the order, thus the application being Can 7 of 2024 is considered and allowed the present applicant be made be add as a party respondent in the proceeding. Be add as a party respondent in the instant proceeding. Full stop. The instant proceeding. Full stop. The matter is otherwise ready for hearing. Let the matter be fixed for hearing of fixed under the heading of hearing along with the Can applications on 2nd week of December 2020 for the 11th of December 2020. Can 7 of 2nd week take it on 7th of December 2020.
7 or 7?
11th of December বললাম তো 11th of December একদম প্রথমে তুমি and এখন প্রথমে পড়ে দেবেন affidavit in opposition filed on behalf of the writ petitioner against Can 7 of 2024 is taken on record. এটা প্রথমেই করতে হবে, না? This is the old matter. It will appear on top. As because this is old matter. Computer will take it off.
Affidavit in opposition dispose of.
Affidavit in opposition, no. Affidavit in opposition against the
Can
Can
7.
7 is taken on record. That's why I passed the judgment. It was taken.
I am asking my lord because if it is disposed of, then I have to file supplementary affidavit. Then my lord, can the liberty be given to file a supplementary affidavit?
Supplementary affidavit, you want to use supplementary affidavit?
Yes, my lord, because they are adding the new document. Then in respect of that, I have to file another documents.
You file anything you want. Okay. The petitioner intends to use supplementary affidavit in support of his writ application. Writ petition. Let the supplementary affidavit be filed within last week of November. Last week of November.
Today is 18, my lord. First week of December.
First, I have to given liberty to them to use the
If
affidavit.
supplementary affidavit, no opposition, man. If they want, they file
If
counter.
they want, they can counter.
Counter, my lord.
So 1 week is required to be given to them.
My lord, so far my knowledge, my lord, against affidavit in opposition, reply is fine.
They have not
Against
used any
supplementary-
affidavit in opposition as because they have not made party. Now they have made party.
Yes, my lord, they can file affidavit in opposition against the writ
Yes,
petition.
that's why I am
Against
asking.
the writ petition, my lord. Against the writ petition. Yes.
That's why
Yes.
let them receive the copy.
Yes. All right.
Okay. কি বললাম বলো? November 2024. Added respondent is at leave to use affidavit in opposition, if any, within first week of December 2020. দিয়ে ওইটা লাস্টে ওই ডেটটা
Then I have to reply, my lord.
সেকেন্ড উইক যে ডেটটা দিয়েছি না। ওকে,
My lord, if they file affidavit in opposition, I have to file reply.
no, you have to see their supplementary affidavit, otherwise how can they want to use supplementary affidavit? Okay, let it be there. If you want to file, then I can give you the time.
It is up to November. Last week of November.
Last week of November. Next.
Lordship, my senior Suman Sen Gupta is appearing for the state. He has met a major accident yesterday, so he will not be attending the court this entire week.
He is not well.
No, he broke his nose, so he will be. No, he will not come this entire week.
But can
Could you kindly?
Position on next Monday.
Could you kindly?
He has broken his nose.
Yes, I have seen this photograph today.
Why? Suffered an accident?
So he was moving towards clean glass. He thought it was could not be. He looked hurriedly and then
It's a bad luck. Very well. Next week. Monday.
এয়ারপোর্টে অনেক সময় হয় সামনে একটু গ্লাসটা দেখতে পাই একদম স্বচ্ছ থাকবে
হ্যাঁ অনেক বড়
Sometime it's happened.
Yes. May I please your lordship, my
Yes.
I appear for the state restaurant.
Well, I'm giving the list of dates, ma'am. My lord, the petitioner.
Yes.
But a vacancy was declared on 23rd July 2018. The Lord will find at page 25 of the writ petition.
This is with regard to the appointment of the distributorship.
Page 30.
Page 25, man.
Yes.
But in pursuance of approval of the government in Food and Supply Department, video number such and such, applications are invited from intending self-help group, registered cooperative society, semi-government, individuals, group of individuals as an entity. You also will kindly mark group of individuals one thing and group of individuals as an entity for filling up the vacancy of MR distributorship at Meena Khan block under Basirat sub-division in the district of North 24 Pargana. While selecting suitable candidate for existing MR distributorship license under the West Bengal Public Insurance System Control 2013, preference may be given to self-help group, especially women self-help group. But we are not concerned with this. We are concerned that I, being a company, I fall within the individual group of individuals as an entity. So I made an application. Now the application is required to made in prescribed form of Form G. So my statutory form is G, and in G form I am to file this application. Then my lord, as I committed to Lord, my lord, that the petitioner company falls within the meaning of definition of distributor. That is, your lordship kindly take to book, my lord, that fine. Controller 2013 at page page 1.8.
Yes.
Last, my lord, distributor.
Yes.
Distributor means a person and includes an individual, registered partnership firm, registered cooperative society, corporation, or company. Your lordship can mark company. So company, though advertisement does not say specifically company, but group of individuals as an entity is a company. And if it is a group of individuals, then so many persons jointly make application. So I, being a company, made an application in Form G. It is an admitted position. Then, my lord, in supersession of this earlier this notification, another notification was issued at page 31, your lordship. Whereas in pursuance of the approval of the government in Food and Supply, that is same first paragraph I am not reading. And whereas while processing the application received against that principal notification, it was observed that publication of the principal notification is not done in the manner provided under the West Bengal Control Act 2013. Now therefore it is notified for the general public that in supersession of the principal notification, applications are invited from intending same my lord, that again has been invited. Now, my lord, your lordship will kindly come to next page, my lord, because everything is same, except one clause has been inserted here, my lord. That is clause 7 at page 32.
Yes.
That has been newly inserted. The applicant in case of individual or group of individuals, it is not meant for individual group of individuals as an entity. It is only for individuals and group of individuals. Should not possess any affiliate dealership, distributorship license on PDS, either in his, oblique her, oblique there. There is no its name or in the name of any member of his, her, their family member, their family. Company cannot have any family member. So, my lord, this notification, now kindly come to last but third paragraph of that notification.
Yes.
Please note that those applicants who have applied earlier on the basis of principal notification may opt to consider his or their application under this notification on submission of an undertaking to the DCFS within last date of September. So my lord, I since made an application, already made an application, I opted for consideration of my application and additional application. That is at page 33. Your lordship, can you come to page 33?
Yes.
Well, this condition number 7 is not applicable for me because I have applied pursuant to the earlier notification. Now, my lord, kindly come to page 36. August 2019, the state cancelled so many vacancies, including the vacancy of Meena Khan.
Page 36.
Page 33, my lord.
7th of August 2019.
My lord, at page 37 is the particular vacancy. Table 2, item 5. As your lordship, my lord, at page 37.
That is the distributorship vacancy.
Yes, these were cancelled.
Cancelled.
That is at page not 24 Meena Khan, table 2, serial 5.
Yes.
Then, my lord, I came before this honorable court. And this honorable court passed an order on 8th August 2019.
Against such cancellation?
No, not against such cancellation. Before that, that is at page 34. This order was passed on 8th August 2019. As your lordship got, my lord. And this vacancy was cancelled on 7th August 2019. Page 36. Lordship got, my lord.
Yes.
Against this order, my lord, not against this order, but before this order came to our knowledge, I filed an application for expeditious disposal of my application. And this honorable court passed an order at page 34. The state advocate appeared but did not mention that this vacancy has been cancelled. So this court passed the order that the principal secretary to expedite and conclude the process within a period of 2 months, without knowledge that this was cancelled. Then, my lord.
Then 7th August 2019, the vacancy was cancelled.
Vacancy was cancelled, and page 38, against that cancellation of vacancy, I came before this honorable court, and this honorable court passed an order at page 38.
Page 38, 40.
Page 38. No, my lord, sorry, my lord. This 38 is the order of the authority pursuant to the order dated 8th August 2019 passed by this honorable court, holding that since the vacancy has already been cancelled, nothing remains to be decided. Then, my lord, I came before the honorable court, that is page 40. That is order dated 18 December 2020.
Yes.
My lord, in this order, kindly come to page 54. What has happened, my lord?
Page 54.
My lord, these are para 22. Before, my lord, I read it para 22, let me tell your lordship, my lord, that this some other applicant in another vacancy challenge this cancellation order, and this honorable court rejected that application, gave that writ petition. Against that writ petition, the said party went before the honorable appellate. As his lordship Sanjeev Banerjee was there, his lordship, their lordship passed the order that this vacancy should be restored, and that vacancy was restored. That matter went up to the Supreme Court, and that order attained finally. Now, in terms of that order, I also filed an application for restoration of that vacancy, and that is, my lord, here. Para 22. The impugned order dated November 20, 2019 has based its reasons on the order dated August 17, 2019. The order dated August 17, 2019 has been held to be arbitrary. That is, my lord, that is order 7, August 7 it should be. Messrs. Kultali Sajan sir, the reasoning of the impugned order cannot be accepted in view of Messrs. Kultali Sajan sir. In such circumstances, writ petition allowed, the writ petitioner being similarly placed and circumcised that of Sajan sir, relief to be granted, the authority will process the application of the petitioner. Therefore, my lord, the vacancy was restored. Then, my lord, your next case 56, certain correction was there, my lord, in that order. Now, my lord, kindly come to page 58. That is the order of rejection. First order of rejection. 28th January 2021. This was pursuant to that order. My application was processed and it was rejected. On the ground, your lordship will kindly find the ground 1, 2, 3. May I read it out, madam. In terms of the subject and reference cited above, this is to inform him that his application dated 20 August 2018, which was reiterated with an undertaking dated 25th January 2019, has been considered and rejected due to the following reasons. 1. The applicant is a company. However, applications were invited only from self-help groups, registered cooperative societies, semi-government bodies, individuals, group of individuals as an entity. Thus, the applicant is found not eligible to apply for MR distributorship against the extended notice. So, this ground was my lord, that being a company, I am not entitled. Second ground, as per application submitted, Mr. Such and Such has his registered office at such and such place. No papers have been submitted to prove the existence of any office in North 24 Pergana district. That is not a condition, but still that has been taken as a ground. Further, Mr. Tamal Kundu, director and authorized signatory of such and such, has submitted copy of his Aadhaar card, being such and such with his address recorded as W.C. Banerjee Street, Kolkata. This violates the eligibility criteria mentioned at serial number 2, that the applicant, in case of individual or group of individuals, your lordship kindly mark my lord, only this criteria is required to be fulfilled if the applicant is individual or group of individuals. Could be permanent resident of North 24 Pergana. So, my lord, first ground is I am a company. Second ground, that being an individual or group of individuals, I have no office or residence in the concerned area. Third, my lord, credit balance of such and such amount was not shown. That is incorrect allegation. No adequate covered space. These 4 grounds are taken. I came before this honorable court, my lord. Your lordship kindly come to page 60. Challenging this order, I came before the honorable court, and this honorable court once again passed the order. Lordship find ordering portion at page 71. In view of the above.
Yes.
This court is of the view the impugned order passed by district controllers is not sustainable under law, and accordingly the same is set aside and passed. The respondent authorities are directed to consider the case of the petitioner for grant of distributorship such as in accordance with law.
Yes.
That order was corrected by another page 73. I am not reading that. 74 is the communication. Now, my lord, the order under challenge in the instant petition is page 76. Well, this is the order of rejection dated 23rd May 2022. It is addressed to the company, directed to the company, subject disposal of such and such, reference judgment and order dated such and such. With reference to above, I am reading it from my lord required portion. Above and in compliance of the order passed by the Honorable High Court at Calcutta on 21st April 2022, in respect of WPA number 5269 of 2021, in the matter of Mr. Sonai Food Marketing Private Limited and another versus State of West Bengal others, this is to inform you that your application for MR distributorship vacancy at Mina Khan block under Basirat subdivision North 24 district BDM Memorial Center has been considered. Now, my lord, the order is started. It appears from scrutiny of papers and verification of records that Mr. Sunai Food Marketing such and such holding a MR distributorship and business at Surekalna. Moja Kansra such and such. That's why your firm fails in respect of eligibility criteria number 7. Now, my lord, they have come with a new ground. Earlier, there were 4 grounds that has been set aside. Now, only to reject my application, they have come with a new ground that I do not fulfill the eligibility criteria number 7. My lord, I have shown your lordship, my lord, that criteria number 7. I am once again, my lord, reading that criteria. That is page 30. Page 32.
Yes.
The appellant in the case of individual oblique group of individuals should not possess any FPS dealership distributorship license on PDS either in his oblique her oblique their name or in the name of any member of his her their family. So, this criteria is not required to fulfill by a company which is admittedly a group of individuals as an entity and also falls within the definition of distributor. This criteria is not meant for them. This is meant for only individual or group of individuals, means so many persons form a group and they jointly make an entity. Therefore, my lord, moreover, my lord, the lordship, I shall place the judgment your required, my lord. A division bench of this honorable court has held in a matter that company falls within the group of individuals as an entity. And that's why they have considered this application matter. Now, vacancy demonstrate the application invited from so many individuals if form a group and jointly make application, then they that is group of individuals. But if there is an entity, juristic person, that is a group of individuals formed and as an entity, juristic person, that means a company. So company does not fall within this criteria of notification.
Yes.
My lord, kindly come to page 31 once again, my lord. Last but 4 lines. The applicant must fulfill the following eligibility criteria. 1. The applicant in the case of individual or group of individuals must be adult citizen of India. The applicant in the case of individual or group of individuals should be permanent resident bracket S of North 24 Pergana district. There are 2 criteria. My lord, you will find that earlier order whereby my application was rejected, that was on the ground that I do not fall within I do not fulfill this criteria, and that has been set aside by this honorable court because company does not require to fulfill this criteria, and that criteria 7 is contrary to the statute, by because Form G is a statutory form, and if statutory form does not make any distinction for this, then they cannot insist upon to fulfill this criteria.
Now, 7 says in the case of individuals or group of individuals should not possess any FPS distribution licenseship on FPS either in his, her or their name.
Not its. If it had a company, then it should be its. That is not there. There is the group of individuals who are making joint application. His and her, male and female single individual. Now, my lord, above this, my lord, this criteria number 7 has been struck down by this one. I am placing that judgment, my lord. So, my lord, if your lordship, totally I have given on the last occasion, I do not know, my lord. Last occasion I have given a judgment. Usual judgment. Single bench. There is not, my lord. This is the judgment with regard to. I am then giving my lord. My lord, will kindly come to last page. Last word. Actually, what happened, my lord, in this case, in my case itself, my lord, earlier application was rejected on the ground of that not having the company. Then this single judge rejected my application. Then I came for the Honorable Appeal Court, and Appeal Court held that page 60, para 9.
Yes.
It is also difficult for this court to appreciate the concept of a group of individuals as an entity restricted only to a fluid aggregation of so-called natural persons. To the mind of this court, the expression group of individuals as an entity, or in other words, acting as an entity, could also relate to a juristic entity, such as the company formed out of a group of individuals being its promoters, shareholders, and directors. So that order was, my lord, of the learned single judge was set aside, and it was held that our application should be considered. So I am entitled to be considered as a juristic person, being a company.
As a group of individuals, as an entity.
Not as a group of individuals only. And this clause is made for group of individuals only. I am again reading, my lord. The applicant in the case of individual or group of individuals should not possess.
So you were saying that the clause 7
Yes.
is not for
Group
the
of
group of individuals as an
As an-
entity.
Yes, that is not for them. As clause number 1 and 2, I have also read before Lordship, my lord, that is applicant who could be the citizen, who could be the permanent resident. Company cannot be a permanent resident of a particular area. Company is not not an individual. So there is no question of residing permanently by a company. Then, my lord, best part of the case is that this judgment has been there. This criteria 7 has been struck down
By this judgment?
by another judgment. I am giving you. Okay. My lord, may I give a coordinate bench of this honorable court. First of all, the lordship kindly see that my lord, in last page 21, Those 1, 2, 7 and 8. These all have been struck down in the case of a company. Page 21.
Page 21.
Page 21, third paragraph.
Yes.
In view of the discussion made above, the impute notices dated such and such are hereby set aside and purged, and consequently the clauses 1, 2, 7 and 8 of the vacancy notice are struck down. These 4 clauses were under challenge by a company that is Kultali. You also find that Kultali Food Marketing. Submission was recorded at page 5.
No, it is in respect of impute notice dated 3rd of December
My lord, that is
and
what
4th of December.
these are the same notification. My lord, all conditions are same. Probably it has been recorded somewhere. Eligibility criteria.
That is the separate notification altogether, I think.
I am saying that.
Page 8, you come.
The applicant must be an Indian citizen. If the applicant be individual, there should be permanent resident. So these 1 and 2 have been struck down.
No, 7 is in respect of 1 lakh deposit. That is different.
That condition. My lord, here. And we come to page 11, my lord. That is the condition. In the notification dated 9 January 2019. And this notification is also 9 January 2019. As you lordship, what, my lord? Page 10. Page 10.
Page 10.
All of the sudden on 9 January 2019. As you lordship, what, my lord? The respondent authority in supersession of earlier vacancy, that same case, my lord, had issued another notice under clause such and such. And this notification kindly see page 31. That is also 9th January 2019. And the eligibility criteria at 7, page 11. The applicant in the case of individuals or group members should not possess any appellate dealership, distributed license or PDS either in his present form. So this 1, 2, 7 and 8, these 4 conditions have been struck down. Here also the similar case, that Italy was also holding another license, and that was the action ground of that Kultali Food Marketing also. An MR2 license in the same name, style such and such, is violates the eligibility criteria mentioned in serial number 7. Here is the same case, my lord. Sonai is getting another license, serial number 7 violates. Therefore, that eligibility, that I could not fulfill that eligibility criteria, your application is rejected. And that has been struck down.
ఇప్పుడు ఈ అన్రిపోర్టెడ్ జడ్జ్ నా బుక్స్ కొన్ని ఇస్తారు
Yes.
My lord, find why it has been struck down. Just for your, my lord, the reason, because in this matter also probably I appeared. Yes, in this matter also I appeared. You know, this was struck down because of the fact that any condition which has been imposed in the vacancy other than the statutory condition cannot be sustained. Now, my lord, kindly come to page 27, that is form G. This is the statutory form. That is at page 27 of the.
Now, what is the criteria in the statute
There is no criteria in the statute.
for engagement of the distributorship?
Yes, there should not be, but so far as no criteria.
26 is the
form, statutory
no,
form.
125, page 1.25.
Twenty-five.
1.25. WPD's maintenance control. 1.25.
Yes.
Clause 26.
Yes. No, this is not. I am saying form 26. That is my lord, page 20. Kindly come to page 27 of my report. Form G. What clause 26 say?
Clause 26 says the eligible criteria of the distributors.
No. Engagement of distributor.
Yes.
So, in the event of resignation, how can the vacancy can be declared? How
Now, on the next page, 1.26, following persons shall not be eligible to apply for license of a distributor.
A person holding a license of distributor or also in his name.
Yes.
Or a person who, and my lord, this is the subsequent amendment. Sir. This amendment has come in a subclause 2IB by with effect from 2020. December IIB. I've been settled by clause 4B with effect 2nd of year. These all clauses were amended in 2020.
Give me the amended provision.
When it can substituted on the page 1.27, substituted by clause 2 of the notification dated 18 December 2018 for the words having no regular meaning.
No, it says 1BH says a corporate or company cannot ask for a license of the distributor.
It was subsequently amended.
It was amended.
This has been now amended. That has been amended. This is your lordship reading the amended clause. That was not at that time.
Okay.
Like at the 2019, this clause was not.
Okay.
That's why when this court held that this form G, you'll also find that my lord, kindly come to page 1.25, last paragraph. On receipt of the approval of the vacancy under subclause 1 or subclause 2, the concerned district controller shall publish the vacancy in official gazette, inviting against this one. This one has been substituted in 14 December 2020.
One has been substituted in the 14th December 2020.
And that is 2019. Vacancies of 2019. No, I'm not on this. The present sir is specifying the eligibility criteria. So they will specify the eligibility criteria and the last date of application. The district controller shall simultaneously publish an advertisement such and such. The last date of these applications have to be made in the statutory form G. And form G, my lord, that is in it, that is at page 27 of my report.
27.
Page 27. That is also in this book also, my lord. That is at page 1.75.
1.75.
Kindly come to page.
Form G.
Yes. Now that is Form G, VDA clause 26(3)(4). So under clause 26, this form is required to be filled up. Again the backend.
See,
My lord, you kindly come to next page 1.76. Clause 20. Does any members of the applicant's family possess FPS or distributor license or PDF? If so, give details. So if I possess, I will have to give details. But that does not debar me from making application or declare me at ineligible candidate. So this is a statutory form, and the condition imposed in the vacancy notice was contrary to this statutory form. That's why that was struck down by the coordinate bench of this honorable.
Yes.
Therefore, my humble submission is that there are two things, my lord. One, the authorities are bent upon to reject my application time and again. Once by holding that the vacancy notification has been withdrawn or cancelled. Second time, when I came court, your application rejected on 1, 2, 3, 4 grounds. When those grounds are struck down, then they have come with a new ground that you have already got a distributorship and you do not you are not eligible under clause 7 of that vacancy. Now that clause 7 of vacancy notification is ultra virus to the statute that has been held by the. Therefore, I am entitled, my application is entitled to be allowed by law. This is my submission. The person whose application has been rejected thrice, first, second, and third, on different grounds. This could have been the ground in the first rejection also, second rejection also. They have not taken this ground because they are all time they are referring me to the court. You go, we are rejecting it, go to the court. You are rejecting, you have to go to the court. This is the third time that I have come before the court. And now, my lord, this is the high time that your lordship will pass the order of granting appointment letter directly. Because your lordship knows that when, my lord, if the authority continues to reject and again for time and again, that the court should pass an order as if the authority has passed an order. That is also in 1986 to 6679.
Okay.
My lord, 1986 to SCC, page 679. Whereas 20, my lord, I am relying upon. Paying for a similar.
1986.
Volume? Volume? 1986, volume 2, SCC 679. Para 20. At page 692, my lord.
Para
Para 20.
20.
20 at page 692. At the bottom, my lord.
Yes.
There is thus no doubt that the high courts in India, exercising their jurisdiction under Article 226, have the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions. Where the government or a public authority has failed to exercise or has wrongly exercised a discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion mala fide or on irrelevant consideration, or by ignoring the relevant consideration and materials, or in such a manner as to frustrate the object of conferring such discretion, or the policy for implementing which such discretion has been conferred. In all such cases, and in any other fit and proper case, a High Court can, in the exercise of its jurisdiction under Article 226, issue a writ of mandamus or a writ in the nature of mandamus, or pass orders and give direction to compel the performance in a proper and lawful manner of the discretion conferred upon the government or a public authority, and in a proper case, in order to prevent injustice resulting to the concerned party, the court may itself pass an order or give direction which the government or the public authority should have passed or given had it properly and lawfully exercised its discretion. This is the third time that I am before this honorable court. And that's why I am praying for a direction, a mandatory order for granting license. This is all, my lord.
So at the time of notification,
My lord.
in the year 2019,
My lord.
the rule was not there
No.
regarding a company to participate in the proceeding.
No, that is the
That time
That
it was
time
not
there
there.
was group of individual as an entity, but specific that because what happened, my lord, I tell you. When this order was passed by the Honorable Division Bench, that company falls within the group of individuals as an entity. Then they took the decision that we shall add a line that company will be divided from. You will also find
Corporation and company.
that after that order, you will also find the date. This order has
Show me the earlier rule.
Earlier rule, your lordship, unamended again. But here, my lord, it is said that this clause has been
Clause 26.
Clause 26. That has been substituted. That is 14 December 2020 substituted by clause 4, my lord. That is 18 December. This clause has come on 16 December 2020. At the footnote, you will also find, my lord, substituted by clause 4. A of the notification of such and such. For words inviting applications from self-help groups, registered was semi such and such as an entity thereof. That was substituted. Unamended clause. I shall give you just I'm asking for the earlier book. I'm placing for Lord Summit. I'm just calling for you.
Subclause Roman 2b.
Yes.
Roman 2 small b. Inserted by clause 4b
IBD, that my lord,
IBD with effect
that has been
not
not printed, that is
not printed clearly. I want the earlier.
I'm asking for that book, my lord.
Okay.
By the time I shall play your lordship. In the meantime, if my learned friend wants to place anything.
Yes.
If the lordship has any query, my lord, I can satisfy your.
So your submission is that
My lord.
at the time of notification dated in the year 2019,
My lord.
the statute, that is rule 26,
My lord.
rule 20, clause 26,
Clause 26 of
clause 26 does not provide any eligible criteria. Only group, only G, form G is there.
E and certain groups were given, that is group of individuals as an entity was there. Because that you will also find in the vacancy notification itself.
Yes.
But it was clarified by this honorable court in the judgment. And after this judgment, that is passed, that is
After the division bench.
division bench. Then after they have come with this clause that the company will not be allowed to participate.
Yes.
My lord, only thing, my lord, so far the unreported judgment is concerned, my lord. Unless I go through it, my lord, it is very difficult to give a reply. But apart from that, the notification which was initially issued, that is, my lord, page 25, 11th July 2018. This is the initial notification for vacancy.
Yes.
And well, pursuant to that, well, the petitioner applied for appointment. And well, if your lordship can come to next page 27. This is the G form.
Page 27 is the form G.
Form G. Lordship, kindly have a look to this.
Applied by the petitioner.
My lord, lordship, I'm just the applicant advertisement such and such, place of vacancy Minaka block under Boshirat subdivision in the district of non-24 Parganas.
Yes.
Name of the applicant in block letters, Sonali Food Private Limited, read petitioner, my lord. Having its registered office as Bethune Row, Kolkata, 7,06,000. Father's name, not applicable. Full residential address of the applicant, not applicable. Lordship, kindly see. Permanent address of the applicant, not applicable. And nothing is explained over there and why it is not applicable. Telephone number, it is given. And whether the applicant's self-help group, cooperative society, semi-government body, it is written no, it is a private limited company. Applicant's date of birth, this is the company date of birth has been given. Educational qualification not applicable since the applicant is a private limited company. Caste certificate if applicable not applicable. Location of the proposed godown, that is Minaka. And particulars of the godown, that is also given. And if kindly come to next page. I'm skipping it over. Lordships kindly come to clause 20. Does any member of the applicant's family possess APS or distributor license on PDS? If so, give details. What is written over the N, A, not applicable, since the applicant is not a private limited, is a private company. So first of all, vacancy was notified specifically for the self-help group and group of individuals, not for the company.
Group of individuals as an entity.
Yes, that is subsequently it has been established by the Honorable Division Bench, as I understand from the...
No, your notification has already stated that the group of individual as an entity.
Malad, may I permit to read it, the 11th July 2018, page 25. Well, in persons of the approval of the Government of Food and Supplies Department, Vidyanova such and such, dated 6/6/2018, read with such and such, applicants are invited from the intending self-help groups, registered cooperative societies, semi-government bodies, individuals, group of individuals within as an entity.
Yes, group of individuals as an entity.
Yes, my lord.
It was already there.
Group of individual bracket close S as an entity.
Yes.
So, my lord, group of individuals here, my lord, after the matter came up before this honorable court, then my lord, it has been decided that group of individuals is amounts to company. But before that, it is not specifically mentioned this
Says group of individuals as an entity.
As an entity.
Means a company.
And that is not subsequently it has been established by this honorable court.
No, your notification says group of individuals
As an entity, but not
means honorable court says, division bench says,
my lord,
means it's
is a company
come under this.
My lord, that is my lord, subsequently it has been established.
Yes.
But this notification has not been set aside. And pursuant to this notification, 11 July 2018, well, petitioners applied for that. And this application was also filed, my lord, 20th August 2018. So considering that provision, my lord, he applied for the company, applied for that, and giving details about this. Then, my lord, it was rejected, and thereafter, my lord, petitioner came so many times, and ultimately, my lord, not ultimately, before that, my lord, then, my lord, that vacancy was cancelled. And 9th January 2019, my lord, fresh notice, that is page 31. Fresh notification was issued.
Yes.
Here also, my lord, lordships, kindly page 31, come to, at the bottom, my lord, the applicant must fulfill the following eligibility criteria. The applicant, in case of the individual or group of individuals, must be adult citizens of India. The applicant, in case of the individual or group of individuals, should be permanent resident of North 24 Parganas district. If it is a group of individuals, if it is an entity, as an entity, is a company, its office has to be over the vacancies plot, vacancy area. And next page, lordships, kindly come
Your
to.
notification doesn't clarify that the clause 2 includes the group of individuals as an entity.
Yes, that is not mentioned.
Not mentioned.
Not mentioned. But pursuant to this notification, petitioner has also opted option.
Opted.
Mala, that is page 33.
That
it has that petitioner has accepted everything about the conditions of the notification. Fresh notification 2019. And my lord opted option and stated, lordships, kindly come to page 33, bottom portion. Hence, we do hereby opt and request you kindly to consider our said application submitted pursuant to said principal notification to treat it done accordingly under the current notification for favor of the next course of action as you read. So, my lord, everything, whatever is there in the principal notification as well as the subsequent notification, accepting this, that company has applied for that. That those notifications were not challenged by the writ petitioners. So, accepting everything, writ petitioner has applied for that. And pursuant to that notification, after, my lord, it was rejected. And finally, when this honorable court declared that the company is also as an entity group of, it should be treated as group of individuals. And if then, my lord, the final writ petition, before this writ petition, the last writ petition which was filed by the writ petitioner, that is the page 60, the order has been passed by the honorable court.
Page 60.
60. Annexure P9.
Yes.
Here, Malan, I'm not giving lots is much trouble, but only thing I'm just placing, if your losses kindly come to page 64. Page 64. That is not internal page, it is not written over there. That is a judgment passed by Honorable Justice Rao. Well, I'm reading the last paragraph. The learned senior counsel submits that the reason number 1 of the impugned order, that the petitioner is the company, and as such not eligible to apply for the distributorship against the notification, as applicants were invited only from self-help group, registered cooperative society, semi-government bodies, individuals, group of individuals as an entity is against the settled provisions of law. On the earlier occasion, the respondent authorities have rejected the claim of the company on the similar ground, and the petitioner has challenged the order before the Honorable Court. And the matter went up to the Honorable Division Bench in an earlier proceeding. The Honorable Division Bench of this court held it is hence incomprehensible that the tender notification should be designed in a manner construing a group of individuals as an entity has limited to eliminating the appellants, the company. It is equally comprehensible that the construction of the expression group of individuals as an entity has been argued as limited to natural persons, whereas the legal grounds norms persuades this court to hold otherwise by purposively interpreting the expression to include within its scope, ambit and meaning juristic entities constituted by a group of individuals. So, my lord, it is no doubt it is a group of individuals as an entity. So, the group of individuals, that is why, my lord, the petitioner has been able to apply for the vacancy. And, my lord, after that, if it is a group of individual as an entity, then if it has already a license in respect of the self-same, not self-same, in respect of the distributors of the in a same category in other districts, then Malad, he is that particular company is not eligible.
But where is the clause?
Malad, that is the clause 7. Clause 7 of the notification.
The clause 7 was declared ultra vires.
That is Malad. This notification was not challenged. Petitioner is accepting this notification. If you will kindly come to page 31.
Yes.
31. Here, Malas, clause 7, this particular provision is there. Page 32. The applicant, in case of individuals or group of individuals, should not possess any APS dealership, distributorship, license, PDS, either in his or her own name, in the name of a member of his family or her family, their family. So this notification was not challenged.
No,
in fact, petitioner accepted.
Unreported judgment, WPA 2836.
Well, that is not given to me. That I have to consider lawsuit. If lawsuit can fix another day so that I can give reply to that effect.
Yes.
And take instruction from the department also.
In that judgment,
My lord.
The coordinate bench of this court, Mr. Rao, Justice Rao,
My lord.
declared the vacancy notice dated 9th of January 2019, same, clause 1, 2, 7, 8, to be ultra vires.
Yes, that 7, my lord, with regard to the not this particular same criteria.
Same notification.
Same notification.
Yes.
That is with regard to the Binaka.
With regard to the same notification.
My lord, that is in respect of the Minaka, not 24 Parganas district. Yes. Minaka.
We hand over the judgment. Paragraph 20, page 21.
Yes.
This is, my lord, this judgment cannot have any retrospective effect because this is, my lord, passed, my lord, on 21st April 2022. These did not say anything over there that the earlier notification, if there is any, that should also not be given effect to.
You take instruction. What is the stand of the?
And apart from that, my lord, that particular, if you is kindly take the option later, that is, my lord, 25th January 2019 by the writ petitioner.
He accepted.
My lord, yes, my lord. If he accepted everything,
all the
can he subsequently disagree with those clauses?
No, it is the case of the petitioner that the eligible criteria not meant for the company.
No, this particular petition, my lord, writ petition, is only for the clause 7.
7.
Challenge.
Not meant for the company.
No, that is already decided in earlier writ petition. First by the Honorable Justice Rao, my lord, that it's a company. Company can be treated as a group of individuals. But this particular, here, my lord, the impugned order, here, my lord, our stand of the state government is something different. Not is a separate, same stand. Here, my lord, I find, if you lordship kindly come to page 76, it appears on the scrutiny papers, verification records, that the Sonai Food Marketing Such and Such Limited is holding a MR distributorship license dated 9/11/2021 and business at Shure Kalna, Mouja, Jamalpur, in the district of Purbo Bardhaman. And so your firm fails in respect of the eligibility criteria number 7.
Yes.
So eligibility criteria 7 was not set aside by the by this honorable court in earlier writ petition.
Yes, it was
So,
set aside.
No, not in this matter.
This matter.
Condition has been declared ultra virus.
The
In any
no, okay. Let him understand. The eligible criteria number 7, according to the eligible criteria number 7, as the company is possessing the distributorship license of same nature, so his candidature was cut down, not considered by the region order dated 23rd of May 2022. But it is the case of the petitioner that the eligible criteria number 7 has already been struck down.
So that is not the stand of the writ petition. Lordship kindly read where they have stated in the writ petition.
They have argued that your
Yes, no such pleading has been taken. Not a single utterance about that. And more so, that notification, that has not been challenged. And option they have exercised. It is an admitted fact that accepting everything, they have exercised their option. And so for the two unreported judgments at concern, if my learned friend, hand over there, then
unreported judgment, in the unreported
next day, I shall have to consider.
Second, the stains in the ground number 8.
Ground number 9 by road.
8 and 9. Both
Justice
8 and
kindly
9.
give sometimes so that I can consult it.
You take, I'm just giving you the details of the pleading. Ground number 8 and 9 has stated the same fact that the coordinate bench has declared ultra virus. Okay, you take instruction.
I got the book there. Earlier book, my lord.
And আমাকে একটু দুটো unreported judgment কপি দিন ওই এই যে একটা দিয়েছি আমরা একটা দিন এই একটা দিয়েছি হ্যাঁ আরেকটা দুটো সাইড করলেন
আইডেন্টিটি আছে
নেক্সট দিন তাহলে আমি এটা জাস্ট পড়ে নিয়ে একটু পড়ে নিয়ে সাবমিশনটা রাখবো Only adjourn next day, so that I can give reply.
This clause was amended. I am showing with mobile.
Please. Lordship kindly give an exit because another matter has already
Yes, give, when it would be possible for you?
Next week, any day, my lord.
Next week?
Any day, my lord.
Okay, please take down. Let the matter appear in the list on appear in the list on December 3rd. December 3rd at 2 p.m.
The same position, madam.
2 p.m.
2 p.m. Specific, madam. That is a specific.
Under the same head.
I'm grateful.
Madam, I am only showing.
this amendment, this was inserted in this mobile. It was inserted on it is 16 December 2020, and this amendment at the bottom says that these amendments shall not be applicable to the vacancies of distributor or FA dealer, which has been notified by the license owner before the publication of this amendment. This 2B was entirely a new amendment, ma'am.
Okay, I'm good.
And that was not in the book. Your lordship will find that was not there earlier.
বইটা দিয়ে দিন। Give me the notification, amended
I
notification.
shall bring this time only to show your lordship my data.
Next.
What is a similar matter? Same matter. I am filing my reply.
May I submit? Just a minute. Well, I am appearing for the state. And
Item number?
I am led by Mr.
3. Item number 3.
This is also Mr. Sonai Food Marketing.
This is with regard to another place. But I am filing my reply to this.
A reply to the
in this
affidavit in
matter,
opposition. Yes,
may,
what?
may I submit? I am appearing on behalf of the state, and I am led by Mr. Robindra Narayan Bhattacharya, and he is appearing in some other court, in court number 16. It may kindly be passed over for the day. It may kindly be taken up tomorrow. I have been requested.
Let it appear on 3rd.
My lord, my lord.
No, I fix it on 3rd.
Third.
Same.
As your lordship pleases.
3rd.
My lord will kindly record that I filed my affidavit in reply.
Okay, please take down. Affidavit in reply filed on behalf of the petitioner to the affidavit in opposition filed by the state respondent is taken on record.
My lord, only one thing subject to my lordship. Your lordship will kindly come to page 60 only. I shall show your lordship.
This matter?
Yes. Only page 61.
60.
60, last page. Second paragraph, as per eligibility criteria number 7, such and such. Same
issue is same.
Right. It will cover both the. Your lordship will kindly.
3rd. Tuesday.
কোনো কপি দেবেন কি কোর্টে যেটা সাবমিট করবেন
বললাম না রিপ্লাই দিয়ে আপনাকে দেওয়া আছে।
Someone asked. I have the state manner. I am led by Mr. Dott.
Dotto is it.
Sir, your lordship is a fair price shop dealer.
Yes.
Case number 1, the cooperative society. Case number 2 is its secretary. You must kindly turn to the first annexure of the petition. Page my lord 27. Can you see? Secretary Basperia Amarpara Cooperative Society is the license at page 27.
Secretary Basperia
Amarpara Cooperative Society.
Yes.
But kindly is the first line subject to the permissions of the West Bengal urban public distribution system.
Yes.
But this is governed under the urban areas. So there are 2 separate control orders. Your lordship knows, one is meant for rural and another is for urban. So for urban is concerned, it has been notified on 12th August 2013 and rural is concerned on 8th August. There are some differences I shall show to your lordship. This is under urban control.
Yes.
Now your lordship kindly turn to page 29. My license has been renewed
Kindly turn serial number 3, date of expiry of the license 31st of December 2025. At page 29.
Page 29.
Fine. Third column, date of expiry of the license 31st December 2025.
দেবু কতক্ষণ দেবু
Third column, left hand side, date of expiry of the license.
Yes.
31st December 2025. Your Lordship knows
This is Form C.
Mine.
Yes.
Nowadays, my lord, license is being renewed for 3 years. Then kindly turn to my lord, page 32. Page 32, a letter addressing to the rationing officer under the concerned rationing area that since my existing shop is not so special, I made an application with all necessary supporting documents that please allow me to use this godown as the additional godown.
Yes.
মানে আমি রিটেল বিষয় অস্থায়ী অতিরিক্ত অনুমতিপত্রের আবেদনপত্র আপনার অবগতির জন্য ফ্যারফাই শপ নাম্বার ট্রান্সফার আপনার স্বল্প পরিসর হওয়ার কারণে অতিরিক্ত বরাদ্দকৃত রেশন সামগ্রী গুদামজাত করা সম্ভব নয়। তাই উক্ত অতিরিক্ত সামগ্রী মজুদের জন্য ধ্বংসসারী বাসগৃহ ব্যবস্থায় একটি গুদাম ঘরের ব্যবস্থা করা হয়েছে। উক্ত গুদাম ঘরের মালিকের অনুমতিপত্র এবং বিদ্যুৎ বিলের প্রতিলিপি এই আবেদনপত্রের সাথে জুড়ে দেওয়া হলো। উপরে উল্লেখিত ঘরটি অতিরিক্ত বরাদ্দকৃত সামগ্রী মজুদের অনুমতি দিয়ে বাধিত করে। মানে অ্যাড্রেসিং টু দ্য rationing officer. That has been acknowledged in the left hand side. Then kindly turn the page. But this is the communication addressing to the joint director by the rationing officer. Government of West Bengal, office of the rationing officer, top the rubber stamp says addressing to the joint director of rationing Hubli, Hatto Bhavan Chinchura. Subject forwarding letter for application regarding permission of extra godown. Enclosed is find the application along with supporting papers of the following owner, representative of the FAPI shop for favor of information and taking necessary action for such. Name, left hand side, serial number, then name of the shop, FPS number, enclosure, remarks. Kindly turn to serial number 12. Secretary Basberia Cooperative Society at serial number 12.
Serial number 12.
Fine. That's the address of, that's the nomenclature of my client, Secretary Basberia. Then my lord, 8 place number has been given. Enclosure, me, 52 Ryland, that's the remarks column, that is the additional godown address. Then my lord, kindly page 34. Serial number, bottom portion, 29. Basberia, that has been recorded. Then kindly turn to page 36. There is a meeting, but that page is not legible. I am not relying on your lordship. Kindly turn to page 36. Details of the temporary godown of fair price shop under Basberia Sabil. Have you got madam?
Yes.
Details of the temporary godown. Well, this is the answer. Approval I have categorically stated. Under Basberia Sabil, serial number 14. Amarpara Cooperative, FPS number, then the new location of the temporary godown. Well, that has been approved. You have to kindly turn to 3 paragraphs of my repetition at page 4. I have categorically stated.
No, where it has been approved.
But I can file a supplementary with that document which is not readable. But possibly page finally turn to page 34, 35. Your lordship copy possibly much better than me.
I can read it. I can read it.
I don't have page 35. I don't have page 35. কোথায়? I don't know. 34 এর পরে আমার নেই তো কিছু। 34 এর পরে 36 ঠিক আছে, আমার কাছে নেই কেন? স্ক্যান করে 34 এর পরে
My junior may read, can I?
Yes.
As per discussion in the initial conference, first July 2015, at Joint Director Hugli Officer S.K. Mondal CI is allowed to submit the paper from the FPS owner regarding permission extra go down for the safe storage of additional ration or commodities, extra ration commodities. For this connection, 16 applicants has been submitted. The next page, submitted by the owner, representatives of FPS. Out of 27 FPS, the applicant may be sent to the Joint Director Hugli for further necessary action towards approval. That's it. Next is approval. It is approval.
Then what the page 36 kindly please. Details of the temporary go downs of choice. It has never been rejected. That is not the case of the state also. This is the approval. According to us, we are keeping storing the goods in the additional go down. We have started after this way.
This is the approval.
Yes.
Then they will also kindly done.
So what is your pleading that the authority has approved it?
Page 4. I am reading from paragraph 3.
Yes.
Your petition states that due to paucity of space in your petitioner's existing godown mentioned in the fair price shop license for loading ration articles, your petitioner on consultation with the officials of the Food and Supplies Department and after conference with the Joint Director of Food and Supplies Hugli on 31st July 2014, I have stated in my reply.
Yes.
Submitted an application on 20th of 2014. Interior paying therein to allow the petitioner to store allotted quota of ration articles at 2 Hongshestori Road, Basberia, Hugli. It was a further states that along with the same presentation dated 28th of August 2014, your petitioners also submitted the necessary documents showing that the same godown is fit for storing of allotted quota of ration articles. Xerox copy of the representation. Your petitioner states that on receipt of the same representation so and so, common petitioners in other 8 shop owners of the area, the rationing officer Basberia prepared a list of the fair price shop owners and their respective additional godowns. And thereafter, by a note sheet forwarded the same to the Joint Director of Rationing Hugli for obtaining necessary approval. Your petitioner could manage to collect the transfer. Your petitioner states that on receipt of the respective applications by the fair price shop owners of Basberia, including your petitioner, and the note sheet for the Joint Director of Rationing forwarded the entire file to the higher authority for obtaining approval. It was a further state that the official of the Food and Supplies Department accorded approval in respect of additional go down, not only your petitioner but also other fair price shop owners of Basberia for storing of ration articles in those additional go down. Xerox copy of the list of showing the approval of additional go down for storing of ration articles in respect of your petitioner number 2 at Hongshestori Road, Basberia, Hugli, and other 8 shop owners is annexed here and Makuda report. That document I have placed in your lordship. Page 36. Your petitioner states that after such approval for storing of ration articles in the additional go down, your petitioner started storing of ration articles in the additional go down situated at Hongshestori Road, Basberia, Hugli. But these are my specific statement in my petition. Kindly once again turn to page 36. This is the list whereby the approval has been granted, which includes serial number 4. That's my client's fair price shop number and details, as also the details of the additional godown.
Yes.
Now, your lordship, kindly turn the page. I shall rely upon later on page 37. Kindly turn to my page 38, which is improved in the present petition. Page 30.
There is a so called.
Kindly see my right hand side. Date of inspection 6th of June 2020. FPS number Secretary so Secretary Basberia so this is to inform you that in the inspection under reference the following irregularities have been found: shortage of 5 quintals of rice, quintals of PDS wheat and quintals of PDS sugar was detected at the time of inspection. The shop is being by an unauthorized person, namely so-and-so, with the intention of the distribution of food grains. He was also reiterated the issue of mentioned so-and-so. FPS signboard was not displayed properly at the fair price shop. Toll-free number was not displayed in the fair price shop. FPS opening schedule was not found displayed in the fair price shop. Number of category-wise tax beneficiary list was not found. Scale come report was not found. Category-wise opening stock for the day was not found by the so-and-so. Amount of the food grains were not found displayed. Complaint book was not found. These are the allegations. Kindly turn to last but one paragraph.
Yes.
As it appears that public distribution system in the service area of the dealer cannot be maintained and of the proceedings drawn a distribution may be shifted due to the followed by controller structure. Therefore, in the interest of the beneficiary on one part of the transfer that are principle of the controller, there will be thereby put under suspension with immediate effect and for the order of circumstances. The focus has been issued and my license has been put under suspension. But I have categorically taken the plea in my writ petition, which has been considered and dealt with by your lordship at the time of passing the interim order also. I have categorically stated, your lordship knows, nowadays, in a week, some cluster days has been fixed. On those days, I have to go to the doorstep of the consumers, following the duration scheme. On that day, it is the circular which suggests shop will be closed. There will be no customer will get from my shop. That's the duty I kept on person in my shop room. So far, my lord, the sample box are concerned, these are concerned. I have bought it with my vehicle for delivery of the same. All the list of beneficiaries, everything is working with me during the course of my duration scheme. That's the law of the land, law of the state is also today with such as a from the controller, amended controller. That we I have taken, but so far my suspension order is concerned, my first permission would be under the urban control order. There is a specific provision which is not in the rural control order.
Yes.
That at the time of placing any license under suspension, there should be a specific averment in the order of suspension that these are the reasons which prompted the authority concerned to put the license under suspension. That is called formation of opinion, which is not in the rural control order. I am governed by the urban control order.
Yes.
But there is also a provision under the control order that at the time of inspection, 100 CRTC shall be followed. I shall show to you. It suggests that if there is a stock verification,
yes,
then entire stocks lying in the godown shall be measured by using weighing machines and laborers.
Yes.
And on demand,
yes.
And on demand of the inspection field, the concerned dealer is bound to
Provide the labors and the owing machine.
I have categorically stated my petition that time and again the person concerned who was present in the shop room, since I was in the duration scheme, requested that take measurement of interval. In their opposition, they have stated no.
There is no opposition. You have directed submission of a report. We have reserved our right to file an opposition because this is not dealt with. This is dealt with specifically the allegations.
Yes.
Only report is there. If necessary, we shall file our opposition.
Well, in that case, my lord, if my learned senior friend says that they have not dealt with my statement.
No, I have not, because there was a direction, where the scope. There was a direction to file a report. I have not dealt with the specific allegations in the writ petition. That I have to do in a proper affidavit in opposition, not in the report.
Very well, then do it. Then use the affidavit.
Yeah, we file yes. But my lord, before that, if my lord, your lordship will, my lord, there is a specific provision for a remedy of appeal under the statute. My lord, on the face of it, my lord, that's your lordship has held in one or two cases. I know I have got one cases where the matter is delegated to the authority. There is a provision for suspension and so cause together. That is in the law. That law is not under challenge. Therefore, it is open. Now, my lord, the remedy of appeal under 30 is there. This is action under section 29.
You use affidavit. You use affidavit better. It will be better to decide all the points altogether.
Because he says that this has not been dealt with because I didn't have the scope. Only a report.
No, very.
So as because
this court has not allowed you to go to the affidavit.
yes, and my report I have said, well, I reserve my right to file an opposition if necessary.
Within 2 weeks?
2 weeks. No, affidavit did.
Within 2 weeks?
Yes. 2 weeks. If I say 2 weeks, my instructing advice, if it is 3 weeks, it is better.
So can it be disposed of within December?
Yes, why not?
No, they have to give in the liberty to.
Lordship gives 2 weeks
Reply.
time for the timing. If necessary, I'll pray for a little extension.
Okay. Okay.
Because
1 week is 1 week is sufficient. Okay.
Same prayer.
Please take down.
That
is not good.
During the course of argument, it appears that state has not given liberty to file, given leave to file affidavit in opposition against the writ petition. Let the leave be granted to the state authority to use the affidavit in opposition against the writ petition within 2 weeks from date. Reply, if any, by the petitioner within 1 week thereafter. Let the matter appear in the list on 11th of December.
My lord.
11th of December.
Lordship only records my submission that the reach is not maintainable because of existence of statutory appeal under.
I have not taken any argument today.
Very well.
Okay.
Very well.
Already the
Mr. Shahara is showing specifically that I have said in paragraph 3 this, paragraph 4 this.
Okay, I understand. I understand. The matter.
So those have to be dealt with specifically. Otherwise, that will amount to admission.
Well, may I get 10 days time, my lord? Just
In that case, let it be 3 weeks for me, and let him take 10 days. So it goes after the
I think, well,
it goes to next year.
Batch, well, motions. Very difficult. There are numbers of today, my lord, there are 20 motions, not 100 motions. All parts.
It's
Short.
Very
So it goes to 2025.
And next year.
Affidavit in opposition within 3 weeks. Affidavit in reply within 2 weeks. Let the matter appear in the list on 18th of December.
18, my lord, not covering possibly, my lord.
18th is the.
No, not. The time your lordship is giving to file opposition and reply.
2 weeks.
Opposition for?
Opposition 3
5
weeks.
5 weeks.
3 weeks.
10 days.
2 weeks.
10
5
days.
weeks. 5 weeks means
Today
3
is today is the 11th.
18th. He prays for 10 days.
18th.
He prays for 10 days. For me, 3 weeks. For Mr. Sahara, 10 days.
Okay. Cannot be appeared before January. Let the matter appear in the list on 6th of January. Is there any interim order?
Yes.
Interim
Interim order 1 week after 6th January till 1 week after the.
interim order passed by this court on the earlier occasion is further extended till 17th of January 2024. 25 or until further whichever is
তিন চার তারিখ সময় ঠিক হয়নি এখন
So, my lord, your lordship is fixing the matter on 6th.
6th.
And
6th of January.
Order will be extended 2 weeks after vacation because till today we do not know when the court is being open. Because
No, no.
calendar has not been filed.
17th.
Okay.
I have given the date 17th.
17th, the interim order will continue and matter will appear on 6th of January.
Fine.
At 2 o'clock or my lord, any other time, I don't know.
Let it appear at 2
All
o'clock.
right, very well.
My lord, item number 13, I am for the petitioner.
Yes.
Actually, on the last occasion, lordship, state needs to file a report, but till date, they did not file any report. Lordship, kindly see the order dated 5th August 2024. Then the matter appear 11 September 2024. Lordship, state has been directed to file report, but till date they did not file any report. On the last occasion also they took time.
Mr. Amritulal Chatterjee is appearing.
Lordship.
Okay, not today. Come on tomorrow.
Obliged.
Next. First call. Next.
59 for the petitioner, my lord. I'll the affidavit of service. I'll have received to my lord vacancy notification memo dated my lord 13th May 2024. My lord, that will appear at my lord serial number 2. The copy, distinct copy has been handed over to your lordship, my lord. Serial number 2, page 30. Your lordship has been pleased to Ramnagar 2, my lord. Page 30. Serial number 2, 153, memo 153, dated 13 May 20. Page 30. A district copy, my lord, I am handling. Right hand side, Ramnagar 2, serial number 2. Happy May 2020. In respect of that block, my lord, and the lordship has been pleased to pass on.
Serial number?
My lord. Serial number, right hand side. Tick mark is there.
Subdivision Kontai block Rampur 2. Serial
In
number?
respect of that, serial number 2, item memo number 153, dated 13th May 2020.
Serial number 2.
Soda of the same subdivision and the memo of earlier matter.
Where is the license?
Similarly,
Where is the license?
a license, my lord, that is page, my lord, 12.
That is different location.
My lord,
Different location. Location is
my
different.
lord, different notice, my lord, in one, my lord,
Different location.
location. My lord,
What is your location of service?
my lord, adjacent, curtailing the units from the petitioner. Existing unit. Where
No.
she has been served.
No, whether
That is, my lord, located in the same Mauja within the area of the
Mauja is different. You see,
my lord.
Mauja Kanpur.
Kanpur. That is also Kanpur, my lord, there.
You are not supplying ration article at Mauja Kanpur.
Kanpur, my lord, your lordship.
Village Deepal, Sasanbad. Kanpur is different
Here
location.
also, my lord, Mauja Kanpur is memo. Mauja Kanpur.
Mauja is Kanpur, but your
within the area where I have been, my lord, distributing MR goods. Within the area, my lord, that's another vacancy is created for the, my lord, adjacent area.
adjacent area may be vacancy declared.
My area is to be curtailed. My units should be curtailed by the authority. They are going to curtail the units.
Why you have pleaded that you have distributing the ration article at Kanpur?
My lord, your lordship, I have stated, my lord, the units which have been there, my lord.
Unit may be there, but why you are saying that you have distributing articles at Mauja Kanpur? You have not said.
To that extent, the area which has been, my lord, created there within the area of the petition.
No, you have to plead. Where is your pleading?
My lord, only that statement is not particular.
Yes, statement is required because it is the different location is there.
Then
Altogether different location.
I have to, my lord, file this application.
You have to state that in my.
Your lordship, correct, my lord. I am not.
You are distributing these articles in that Mauja, in that Mauja, in that Mauja.
My lord, I am not opposing, my lord. Your lordship.
Because the location is different. You understand? It is not for me to understand the location or area. You have to plead with affidavit. Otherwise,
that's to be stated, my lord, in a further.
You use supplementary affidavit. Okay. Please take down. Otherwise, better to file. Okay, as you wish. Petitioner is at leave to file supplementary affidavit within a week.
10 days time.
Within 10 days. Let the matter appear in the last week of November. Another same heading. Next. Next.
For the respondent statement for the petition.
Yes, item number
20.
20.
Petitioner's father was the modified ration dealer for the village Tantuara, police station Jhalda, and subdivision Jhalda under Purulia district. The father of the petitioner had also trade license. Kindly come to my lord, page 18, my lord. The license in favor of the father of the petitioner, my lord, Sishtidhar Kumar.
Sishtidhar Kumar.
Yes. And village for village Tantuara, PS Kotsila, now Kotsila, previously Jhalda, district Purulia. And my lord, he has also the SK well and others license, my lord, and trade license issued by the Panchayat, my lord, who died on 21st 29th April 2021, my lord, leaving behind his one daughter and two sons, my lord. Page 24, my lord. Thereafter, my lord, on 22nd June 2021, the petitioner intimated to the concerned authority the incident of the death of his father, my lord, and thereafter, my lord, he has, on the same day, my lord, he has applied for compensation license on compassionate ground as died in harness, my lord. And my lord, the concerned authority, and he has also submitted the no objection from his brothers and sister, my lord, and the concerned authority, all on a sudden, my lord, kindly come to my lord, page P6, my lord. P7, P8, my lord. Page 32, my lord. Applied vacancy for the said post without considering my application. Inviting application, the grant of license against the vacancy, fair price of page 32. For notification, my lord, I am the son entitled to get the opportunity.
Have you placed any representation?
My lord, my application is there, my lord, and thereafter, my lord, I have also made an.
Where is your representation?
My application for my page 26, my lord, 25 and 26, the application on prescribed format, my lord. That should be considered, my lord. Page 25, 26, my lord. Thereafter, my lord, after publish the notification, my lord, one.
What is page 41?
Legal notice. 41 is.
My lord, that is a legal notice, my
legal
lord.
notice.
That is a legal
Not
notice.
through an advocate, my.
Yes.
My lord, only two submissions, my lord. My lord, since my learned friend submitted that NOC from brother and sister is there, my lord. Just like to point out, my lord, that NOC from brother has not been annexed to this writ petition, my lord. So that is one. That is one submission, my lord. Secondly, my lord, since the application for consideration has already been made, which is, my lord, at page 25, my lord, kindly direct the respondent authorities to consider that application, my lord, and then render their decision, my lord.
Whether it is the same location?
Same location, my lord. Kindly come to my lord.
Yes. See the license?
License, my lord, Tantuada, the village. And
area of
under Jhal,
service, Amra, Baba Metiala,
my lord.
Chamakka, Choto Metiala, Dhamra.
Mauja jail number, the is area of that dealership, my lord.
Yes.
Is my lord kindly Mauja and jail number is Tantuada.
That may be
205.
separate. Whether your service is when is there.
My lord, on the same, my lord.
Your license is on the different location, I think.
Village Tantuada. And P3, my trade license, my lord. Tantuada Courtsila location. And my lord, one dealer has some area, my lord. 2 or 3 villages. These villages are under the Tatuada, my lord.
Have you stated in your writ petition that you are serving the ration articles in those areas?
My lord. He was a dealer. I have specifically stated, my lord. This area I have not mentioned, my lord.
Then
Tatuada village, that ground, that dealership situated on that village, my lord.
there are two names, one Tatuada and another is Tataara.
That is, my lord, there. Tatuada in Purulia district, my lord, in some computer in some dispute, my lord, regarding
No.
the village name, my lord.
No, you see the notification? There are name Tatuada and Tataara.
Tatuada and Tataada.
Yes, Tatara.
Tatuada, that is also Tatuada, my lord. Moja, jail number Tatuada, GP ward Tatuada, the post office Tatuada, police station Courtsil.
Whatever may be.
My lord.
Okay, very well. You take decision.
My lord, till that, this time, my lord, this notice should be stayed, my lord.
My lord, let the process continue subject to the outcome of the writ petition, my lord.
Outcome of the writ petition, what does it mean? I shall dispose of the writ petition today itself. You take decision within 6 weeks. Till then, you should shall not issue the license.
My lord.
You may proceed, but you shall not issue the license.
Very well, my lord. Most grateful.
Please take down. The father of the writ petitioner, namely Srishtidhar Kumar. Srishtidhar Kumar was a emmer dealer. Who died on 29th of April 2021, leaving behind 2 sons, 1 daughter. It is the case, next, it is the case of the petitioner that he applied for the license of emmer dealership on compassionate ground before the authority concerned on when you filed the application?
26th June, my lord.
22nd June.
22nd June 2021. Full stop. He also placed the specific application through Form C along with the requisite fees. Full stop. It is the case of the petitioner that the said application also annexed the no objection of other legal heirs of deceased Srishtidhar, deceased license holder. It is the positive case of the petitioner that the concerned authority has not considered the application of the present petitioner on compassionate ground, but has issued a fresh vacancy. He prayed for necessary direction so that the vacancy notification dated
31st May 2020.
31st May 2024 be cancelled. Next paragraph. Learned counsel appearing on behalf of the state authority has submitted that the no objection certificate issued by the brother, issued by the legal heirs of the deceased MR dealer within bracket Sridhar Kumar was not annexed with the writ petition. Moreover, the notification has already been issued at this juncture that cannot be stalled. Having heard the learned counsel for the parties, also considering the materials on record, it is the case of the petitioner that he is the son of the it is admitted fact of the petitioner that it is admitted fact that petitioner is one of the son of the deceased MR dealer Sridhar Kumar. It is the positive fact of the petitioner. No, it appears from annexure P6 of the writ petition that petitioner has applied for license under compassionate ground in Form C. Full stop. It is true that the authority concerned has to consider the has to dispose of the application of the petitioner before issuing the vacancy notification. At this juncture, I find justification to pass an appropriate order. Full stop. The respondent number, who is the respondent? Subdivisional controller, respondent number 4. Respondent number 4 is directed to take decision in respect of the application of the petitioner dated 22/6/2021 for providing him the license on compassionate ground within 6 weeks from date. The concern respondent number 4 shall pass a reasoned order according to the provisions of law after hearing the present petitioner and shall pass the and shall serve the reasoned order, serve the reasoned order upon the petitioner within 2 weeks thereafter. Till the next paragraph. Till then, the state authority may proceed to act upon the notification dated 31st May of 2024, but so far as the commissioning of license is concerned, that cannot be issued till that decision be intimated to the petitioner as mentioned herein above. Another above observation, the writ petition is disposed of. As the affidavits are not exchanged, the allegation made in the writ petition shall be deemed to have been not admitted. Next paragraph. This court has not gone into the merit of this matter. The concerned respondent number 4 is at leave to dispose of the application of the petitioner according to the law without being influenced by any observation of this court in this writ petition. This person.
Thank you.
Next.
This is regarding my lord curtailment of my lord. Yes.
What is the issue?
My lord, advertisement has been published by curtailing my lord the area my lord of this petitioner.
Who is appearing for the state? Have you served?
My lord, already my lord served.
Affidavit of service?
My lord, this is the order, my lord. I need not show this, but my lord.
You show me your license first.
License, my lord, at my lord page
19.
Page 19.
Page 19. Notification.
Page 21.
Notification, page 21.
Serial number.
Serial number, Lordship, kindly see column 2, subdivision, Howrah Sodor, block Panchla. Lord, serial number 1.
Same location.
My lord, same location.
POPS village post Gabaria.
That notification has been published by the DDPS, Deputy Director. Respond note 2. See. Eso.
Miss Sinha has left the court, Your Lordship, just few minutes ago.
নামটা রেকর্ড থাকলে একই তো অর্ডার।
Supplying ration articles, Gabriel. Okay. Very well. Yes.
Lordship, I am not having the brief and instruction, Your Lordship. Miss Sinha left.
Similar type of direction.
As Your Lordship, please.
Okay. Give me the name.
Yes, Your Lordship. Deeply.
Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Similar direction. না এগুলো করো পিএস ভ্যাকেন্সি মধ্যে আছে ঠিক আছে বুঝতে পেরেছো নিয়ে নাও নামগুলো
Deeply obliged.
Okay, that's all for today. Your matter cannot reach today. Come on tomorrow.
It will come tomorrow, madam.
Yes, it will come tomorrow.
এটা দেখো তো। হ্যাঁ কোনটা এটা